August 21st.
Okay. Do you have anything, Ms. Shaw? Mr. Henry?
And I don't know if she's done it yet.
No, that's why I should go to rest of
Yeah, we haven't got an approval yet either.
Do you anticipate a possible denial?
No.
You want to go,
But then I'm really
Is she here now?
optimistic about it. Yes.
you want to do a T-Res now?
Sure.
Yes.
Yeah.
Yeah, okay. We'll send her now and then we'll sit you off like a week, give or
Okay.
take.
Can I transfer away for a week?
Yeah.
Cool, thanks.
Judge, you ready for arraignments?
Yeah.
Oh, sorry.
What's wrong?
Oh, that's it. Very good.
Top of 11, Jensen. Come on up.
Good file. Thank you for letting us know. No, I know you did. I thought she was just fine. and making sense.
Do you speak English, ma'am?
I understand better less.
I'm sorry?
I understand.
Ma'am, you're charged with failure to stop and give information. You're facing up to 6 months in jail and or $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. We're going to do probable cause to see whether we are going forward with the case or not.
On 7/1/2025, CW stated he arrived at work at HEB located at 10919 Louetta, Harris County, Texas. CW stated another vehicle sideswiped his vehicle. CW then got out to observe the damage. CW defendant then drove. CW then drove after defendants. CW began honking at defendant. CW drove alongside her and tried to flag her down. Defendant took a sharp turn in an attempt to evade. And CW took a picture of defendant's license plate and stated he observed a white female with blonde hair behind the driver's seat. Officers observed the suspect's vehicle was involved in a Class C offense. The defendant as in a Class C offense. CW's ID, the defendant from a photo. The total damages were $1,000.
Did you say that she hit?
She sideswiped him.
Oh, sideswipe. At the HEB?
Yes, Judge.
Okay. Does she have a license?
It's just, so they just.
Ma'am, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you are ordered not to drive unless you have a valid Texas driver license and liability insurance in your name. Do you understand? If you violate these conditions, if you pick up a new case, I will revoke your bond and put you in jail. Do you understand, ma'am? Do you have the ability to hire a lawyer?
No,
What do you do for a living?
I'm a hitchhiker. I get $600, $770 from Social Security.
Okay, we can have you apply for a court-appointed lawyer. I need to know everything about you and then we'll take a look to see whether you qualify. Deputy Williams will give you an application and we'll have you sign a receipt and then we'll have you take a seat in one of the pews over there, please. Please.
All right, Judge, top of 14, McMurray.
Ma'am, you were charged with terroristic threat of a family or household member. That makes it a Class A misdemeanor. You were facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am. Okay,
On or about November 4th, 2025, the defendant, along with her children, was picked up by her mother, the complainant, and brought to the complainant's apartment at 1801 Smith Street in Harris County. The defendant became angry at CW for statements about her living conditions and stated, "I will slap you and I'll kill you," with profanities. The defendant also was swinging and charging at CW. The CW asked the defendant to leave, and the defendant left with the children. The complainant then called the police. Officers presented the CW with the defendant's date of birth and driver's license number and positively identified her daughter as the victim.
got it. Ms. McMurray, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you were ordered not to have any contact with this complaining witness and not to be in possession of any weapons. I am entering now what's called a magistrate's order for emergency protection that identifies Ms. Britton as a protected individual. You cannot commit family violence or an assault against this person and act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of the Smith apartment 911. If you violate this, they can file additional cases against you, and a violation of a protective order is the capital murder of misdemeanors. You understand? I have no problems putting people in jail. I have no problems making your bond $50,000, $100,000, $500,000. I will protect my community at all costs. Do you understand me? Do you have the ability to hire a lawyer? What do you do for a living? Why would you just stop working there?
It was like problems with the manager and stuff. He ended up getting new managers and stuff, and he just got like messy.
Most people will get a new job before they leave an old one. It is time for you to get a full-time job. And I am also making that a condition, and I'm bringing you back in 2 weeks, and I want to see what you have done to get a job to the tune of around 15 to 20 applications. Do you understand? All right, we'll have you fill out an application. We're going to have bond conditions created for you to sign, and then we'll have you take a seat in the pew minute. Please.
All right, Judge, next is bottom of
If you can file
19, Rodriguez.
no weapons, no contact, please. She needs to sign the MOAB too.
Yes.
Deputy Williams, she needs to come up, sign the MOAB. What did you say, Victoria?
Rodriguez on page 19.
You speak English, sir. Mr. Rodriguez, you're charged with driving while intoxicated, second offense. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. Okay.
On or about August 8, 2026, officers responded to a crash at 900 block of Gregg Street, a public street in Harris County, Texas, where officers identified the defendant. The defendant stated he was operating the black Cadillac Escalade. When he crashed, officers observed a strong odor of alcoholic beverage and slurred speech from the defendant. The defendant refused a standard field sobriety test and refused the blood sample. A search warrant was obtained for the defendant's blood. and results are pending.
Did they do any field sobriety tests?
He refused to.
Oh, total refusal. Got it. All right. Mr. Rodriguez, I'm going to find that there's did you say there was an odor of alcohol?
Odor of alcohol, slurred speech.
Got it. And then the accident. Got it. Mr. Rodriguez, I'm going to find that there's probable cause to go forward with your case as a condition of your bond. You were ordered not to consume alcohol, illegal drugs, or unprescribed controlled medication. Because this is a second offense, I'm now ordering you not to drive any vehicle that's not equipped with an ignition and a lock on it. If you're caught driving one, I will put you in jail. You understand? I'm putting you in jail regardless today. You have an open felony warrant. Your bond denied on the felony, so you will be going into custody today. We'll appoint you a lawyer, but I'm serious. You endanger my community. It's just not going to go well for you. Do you understand me? Does he have a license to drive? We heard from Burnett.
He was here earlier. It's a legit motion.
I was just checking.
Okay. I'm waiting on Mr. Burnett. Give me 5 minutes. I'm gonna see if he's out there and then I mean, we've got a panel, so we're ready. All right.
Six, so.
Go. Yeah. Of course. So let's have him sign conditions and then we'll put him in custody.
All right, Judge, next is page 23, Vega.
Can you file the guardian interlock paperwork?
Vega? Yes, Judge.
Good morning, Mr. Vega.
Good morning.
Sir, you're charged with driving on a suspended license. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
On 8/18/2026 in Harris County, Texas, officer observed a white Nissan with an expired registration and conducted a traffic stop. Officer ID'd the defendant by Texas drivers.
I really don't give a rat's behind what you have. Look at me. You really don't care what you have to do in this life. I don't care that you have to work. I don't care that you have to go to school. I don't care that you need groceries. I don't care that you have to go to the hospital. If you don't have a valid Texas driver license and liability and approval from us, do not drive. You will be signing an affidavit with me today. This is a promise that you're going to make to me that you're not going to drive. If you do, I can have a contempt hearing every time you drive. You can be slapped with 180 days and a $500 fine. Do you understand?
Yes, sir.
We are going to reset your case to give you time to hire a lawyer. So I'm going to have you come up here, swear to us, and then we'll get you to sign a reset, and then we'll get you out of here. When you come blank, please have a lawyer.
Yes.
Okay.
That's it for now, Judge.
So.
Person waiting. Your sister. I think it's a water. You said Mr. Urban, you know, operating on the thing about that.
Yes.
Yes. Oh, yeah.
What is Monday for Lisa? No, I haven't noticed that there is such a Danila?
Good morning, Mr. Burnett. It's David Fleischer. It's 9:10. We are ready for you. We've got a panel. Would you mind coming to court 5? Thank you.
You want us to send you the attorney not so.
Hey,
Just said.
do you have silver back there? Silver
Oh, so.
in the jail? She's on the docket today. She shows she's in custody. Silva?
Yeah, in custody.
Okay, don't send her down because we need to talk to her, please.
All right. Go ahead and try to clear that. Slide over. So what can you do? Oh,
Mr. Burnett, can I borrow you for a second, please? I need you to take a look at the jury list so that we can go get the panel. Shantia?
Yes.
We need to give you the jury list.
Yeah, that's one.
Mr. Burnett, take 5 to take a look so we can go get them, please. Thanks.
This case, I just feel that it's hard.
Jackson should be fixed. There you go. Raise your right hand. Raise your right hand. You solemnly swear or affirm or take sure that that is true. Yes. Okay, yes. Absolutely. This is an off property change.
Sure, what is this?
2627493.
9-3?
Yes. Martinez.
Okay,
I was trained in one this morning, saying that, we approached you last week about getting a spring device and allowing him to drive trucks for work if he provided with you phone it.
yes, I remember.
He did provide that proof, this morning. I was not in Florida at that time, so I just wanted to verify if that was.
But I'd like you to first verify with the work to see
We
you
can
know.
verify, we got the, letter from his job. Would you like to see it?
No, but have you verified with the job?
I'm gonna call the job.
Mhm.
HR services for all job agencies, we just get the, job. I believe the case managers that you can call right now.
Can or cannot?
They are able to, I could see if I'm.
Yeah, please. That'd be great. I just want to verify that it's actually true, correct, and then go from there. And then if that's the case, then yes, he still has to have the interlock on his personal vehicle, and then he has a scram, right? He needs a scram.
I'll see if we can get that, call done right this minute.
Okay, thanks.
Yes. If those one with me.
No,
Guys, do you mind grabbing Mr. Burnett? Mr. Burnett, do you mind grabbing him? Okay, and he's like a shuffle. He's like a shuffle. Hey, we need your jury list back. He's doing a shuffle. Etch, he's shuffling real quick, okay? Yeah, I need your list back, please. No, I think you're good. We're going on Mr. Burnett's case. Are you going on 6 or no? Are you going in 6? No? Are you going in 6?
Yeah,
Okay.
I mean, we haven't been reset, but Shelby said no, I'm sure he gave me a new date, but said.
I guess we did the 22nd for the last one, right?
We set one yesterday, yes, we did on the 22nd.
You want to do the same day?
I think we set one on the 29th. September 22nd.
Time for your reset.
We can do the same day. I don't have any thoughts set on that day, but I have some.
Yeah, I know.
the day before.
Right.
Just have to tell you. She gets the first.
Yes. Okay, got it. Yes. You want to call them to sign?
Judge Fleischer.
All this. It's not gonna go strong, but they got another testimony for James.
Yeah. All right, you'll sign, so just gonna.
No, it's, on the time that people need to.
Are you planning on doing a PowerPoint?
Yes.
It doesn't work on a Mac. Do you have a PC? It will not, the system will not recognize a Mac. It only does PCs. Even with your dongle, it will not work.
Is it a?
Yes.
Yeah, so, right. With them, they'll usually pretty good. They're,
And I'll leave it for Ron and everything. He's on something, this week, it's for the money.
hey, hi, Ally.
I was just approaching on the other trial case, and like, other trial
You
case.
can reset it.
Okay.
Yeah.
Thank you.
Just, how old is your case?
Summer.
So, yeah, 30, 60,
Thank you.
for sure.
So where's that?
No. It's tomorrow.
Okay.
Oh, yeah, yes, so I was ask them about the government, it's okay, okay, so I haven't seen that.
Hey. Marcus filed a motion to withdraw on Velasquez.
Yes.
Did you
She
appoint,
told me this morning, yes.
did you already appoint or no?
It's going to the PDO's mental health.
Huh,
So
okay.
As soon as Sebastian.
Should I go ahead and grant it?
Yes, yes.
Usually you don't have all those people. She has to balance. This is the thing that's like.
State and defense. Costa,
Thank you.
different way.
We should just chew them.
Michelle.
Yeah.
Okay, decided this. Oh, no.
Who's there?
Did he run it already?
No, Judge,
It's
I
going
told
now.
him I will shuffle. We have to make it. We need it. Let's take a all for safety space. You have to be transient. It's difficult. I'm not sure one. So just kind of get the context of things. Right, they look pretty.
Thanks, Edge. Here, you can have mine.
Oh, you want this one?
No,
You want
Oh, that one?
Yeah, that's. The last part of the remember survey.
I'm assuming that's if I'm not, since you don't have. That's what everyone.
Okay. Yeah, no problem.
Yeah, I can actually, not to confirm, what they said of total. But it's like, you know, how they got in this. Yeah. Yeah. Yeah.
Harris,
Well, I'll have to look at the fault. What is she has to do? And then the signs.
getting the sign that you said.
So like, most, I would just be this cute.
yeah.
Hi,
Yeah.
come on in. Who you got? Did you just get appointed?
I'm sorry?
Did you just get appointed?
No, not too long ago.
Oh, it's just an old case, sorry. It's from 2025. Okay. What do you want to do?
So Judge, it looks like, we're talking to mental health in regards to potentially jail reentry. My understanding, speaking to the defense and also speaking to, our back spoke to the complainant, will indicate that the defendant went to a long-term treatment facility. And they have been doing some like mental health assistance in jail.
Great.
So Lawrence has been working on it and trying to confirm those details and see what he's gonna do. We just wanna like.
I'm down as long as they pick him up and take him.
Yeah. So
Not
that's
on his
what we
own.
wanna let you know that it might be something that she'll put in your queue while.
Yeah, I'm certainly down with that, as long as they take him, because I don't know if we can trust him to go on his own accord, so.
I don't think it's a matter of trust, I just want to make sure it's housed, that's what my focus and making sure it's housing.
They only do for so long, unfortunately. It's not,
We have other resources, we have social work, we have resources.
so you're not talking about the Ed Emmett Center, is that what you're saying?
And we're doing that right now. But I've also been building something for the future.
That'd be great, because the Ed Emmett thing only lasts for, what, a day? A couple hours.
You can go for a couple of weeks and then there's some things that we can do there, but.
Okay, yeah, I'm, regardless, I'm down. And then, Veronica, we will need probably a PR bond for Mr. Smith.
But once she does that, Judge, we can email and then let you know, like,
Yeah.
it's gonna be in the queue.
Okay,
and
so
then,
just
we'll do the
be on the
PR.
lookout and be ready. At some point, we'll get the jail release instructions and then we'll have to process that PR bond for the next day for the 2 p.m. thing. Okay, cool.
Thank you, Judge.
For sure.
So hopefully she'll get back to us soon.
You said both are on board?
Yeah. Okay, then everyone, yeah.
I just, it feels so nice.
Excuse me.
Judge, do you have a financial affidavit up there?
No.
Alyssa, do you have it?
I do not have one, no. Do you know what specific name?
Miss Murray?
No, I think she's still filming it.
Oh. Are you done with your? Yes, come on up, please.
Judge.
Yeah.
You want a quick signing modifications?
Yeah.
Was able to verify that anybody doesn't work there is right.
Okay, so let's do the scram and then we'll allow them to do it. Okay.
Yes. So the second is, and one of them, no. You just like, it's good shit.
That's the part. That sounds like I'm kidding. You never know. Vega? No, I could just put it there for. Yes. Anything step, that's the name of that's the thing.
It's great.
Here's the. But. So.
This, is this the new list?
So, yes, anyway.
Yeah.
Mr. Jaworski, hi.
Yesterday when I zoomed in, the long court.
That's all right.
But I did have.
We're happy to have you.
So set for trial, Villarreal, and
Let me
you said you were gonna reset it.
Yes, let me just see how far, because,
What date are you?
yeah, probably like 30 to 60 days,
Okay,
give or
sorry.
take. Yeah, for sure.
Thank you.
Yeah, of course.
Maybe
Shoot.
the other transaction for, the area, I don't have the Gina.
Who it is?
The gentleman that showed up for Mr. Garcia. He said that the Gary, the guy that has the two other charges.
Oh, do you have the cause number to the case?
I have the cost number, I have only the Gary's email. I don't have the other guy's email.
What do you mean the other guy? You have DeGaren's email?
I guess I'm just.
Yeah. Well, that's the only one on the case, right? He's the only one on it. He's the hired lawyer on it. He's got, I didn't see anyone else on the case.
I'll put that then.
Did you get a,
Right.
really?
Mhm.
Okay.
No connection. Sorry. So I'm letting him know.
He's gonna be blown away by that one.
I know.
Simon, just a minute.
This one.
One second. All right, go ahead and sign. All right, it's up. Yes. Okay. I would just, you just leave it there, because I'm just double check. So you don't want to sometimes I get started. How's so from the office, they do not consider the 7:30. So 17 or the chunk board.
The 24th.
Plus.
Maybe it's you very good.
And this is good. Well, I think the candidates.
Yes, yeah, I'll 17 or 24.
17.
Where's yes, provincial order is supposed to be back today. November 2020. Yes, that we will have to go to. That one will. And September 29th.
That's it. We said we have Wilson, Jackson's, Jackson's, that's the end. And
Hey, morning.
I'll be showing my case to you about today with Mr. Barnett.
Okay.
I want to make sure you put.
Yeah, absolutely. Of course. Sure.
Thank you.
Yep. Are you,
7 weeks.
Mr. Weeks, are you,
City second.
Yes.
Okay.
he's doing board eye though.
Yes, very
Got it. Okay.
Alva, you have to. Alva, we're waiting for.
Okay, Before we begin, we just want to address some prior preliminary matters.
Okay. Let's do it now while we're waiting. Mr. Burnett, can you come up real quick? All right, guys, we're going on the record. If you need to talk, use a phone, please go outside. Ramona, you ready?
Yes, sir.
All right, we are on the record and cause number 2610088. It's the state of Texas versus Janae Green. It is approximately 9:42 in the morning on August 25th, 2026. First things first is let me have you guys announce yourselves for purposes of the record. State going first,
Shakir Shaw for the state.
Karina Batista on behalf of the state.
defense.
Ari Burnett on behalf of the defendant.
Zane Weeks on behalf of the defendant.
Okay. I see a whole host of motions that you have filed. Have you filed any motions, state?
No, Judge, but I had one, oral motion based on, checking defense's, word art tonight, and we discussed it, and I think we're not on the same page, so I just wanted to bring that up.
Okay,
Defense wants to go into, effects of, concussion on someone during the word art. There is really no evidence in this case that there was a concussion. The defendant was thoroughly checked at the hospital, had a CT scan, and there was no sign of concussion. So to bring that up, it will just confuse the potential jurors, put the seed in their head that there is probably a concussion there.
was there an accident in this case?
Yes.
3-car accident. Judge.
There was an accident, yes. She does have a black eye or a contusion as, defense put it, but there's no concussion. There's a huge difference.
We would also say it's improper voir dire. There's not going to be any medical testimony in regards to that. With regards to the purposes of voir dire is to talk about their opinions and to talk about the law, not to be talking about potential facts in the case. And by him mentioning concussions, could potentially go into facts that may or may not come from each other.
And Your Honor, it's my argument, first of all, that I think it's wholly relevant. She has a large contusion on her face. It's a 3-car accident. multiple officers state that she has likely had a head injury. She was just in a car crash.
But you can't get into the facts of the case.
I'm not getting into the facts of the case, Judge, but I do think it is important. As far as it goes, as far as SFSTs and other things, it is a head injury is something that is to be considered when it comes to a person's normal.
So
mental and physical faculties.
I agree that it could, but I think that you need to be very, very general if that's what you want to get into. Don't start
Absolutely.
mentioning contusions or start mentioning,
I plan to talk about, on that slide, I just plan to talk about college football, Judge, and it's a little bit of an icebreaker for the jury. And
I'm okay with it, but I don't want you to get into the
but I
facts.
won't speak.
One at a time.
My apologies.
Go ahead.
But no, I don't plan on even bringing up car crash or contusions to the jury in the sense of that nature. I just want to ask about mental and physical faculties and what they believe a head injury may show. But
I think that, if you're going to get into specific facts, that's, I think, off limits. So I would, especially if you don't have any kind of, are there any medical records that have been filed in the case?
There are medical records and she has been cleared for concussion or any type of head injury other than contusion.
I mean, certainly, I think car wreck, I think that's okay. But if you start getting into concussions and contusions and to scrapes and head injuries, and that's getting more into the facts of the case. But I think generally speaking, car wrecks, ladies and gentlemen of the jury, what things may happen when you have a DWI? Someone, okay, well, this, potentially car accident, okay. And then, but don't get into rules. Please, specific facts.
And so that's why we're objecting to specifically the slide that he has about football players and concussions, because that's gonna go specifically into a type of potential medical issue, right? If you're talking about like how you say during the slide, when we talk about mental, physical, what can hinder that, the mental or physical, generalizing, but to specifically have a slide dedicated to concussions or contusions, I think that's improper for hire.
And Your Honor, I would completely disagree. I think the defense has a right to voir dire on any issue that could come about, especially when we're talking about a case that did have a car accident, a 3-car accident that was really bad.
But what does football have to do with that?
And I think that is the way I was able to keep it generalized. And there's a lot to do with head injuries and how that can affect STs,
but
how these things can do. And I think I'd have the right to voir dire on that in any DWI case. Even if there wasn't an accident or a concussion, I think I would have the right to ask the jury, what is a person's normal mental and physical faculties? How could a head injury affect that? What might you see that would give you some
I agree with you.
details? I plan on
But
keeping
just
it
don't-
general. I don't
Don't
plan
get
on going
into
any facts.
concussion, don't get into contusions, but car wreck's certainly okay. If you want to allude to football, okay, I mean, I think that's a little out, but okay. But, can you take it out of the slide?
I'd like to. I think.
Will you take it out of the slide, please, as far as concussion is concerned?
Nothing in the slide says concussion. It's just a picture of Tua Tagovailoa.
Can you show it to me real quick?
Yes, yes. And it says CFD for college football. But regardless, I think it goes to more than just whether or not she has a concussion, but it goes to
I'm not,
the officer's ass.
I agree with you, but in voir dire, you can't get into the facts of the case. That you can develop it through testimony while in trial.
Well, I would ask that the state not be allowed to talk about any of the car crashes. I believe, what slide is that?
Well, but if you're gonna talk about car crashes, then they can talk about car crashes,
Well,
right?
I think if they can talk about car crashes, I can talk about possible concussions.
We don't have anything.
Okay, so just please don't talk about concussions, okay?
And I'm still just not understanding the
So
possibility.
you have a problem with this?
That's what they have.
Yes,
Well,
there's-
when I asked, because I didn't know what that was, and when I asked what it was about, I was told that there was gonna be a discussion about concussions and how that could affect
Okay.
somebody's mental, physical faculties, and I'm just saying there is no concussion here, so to get that in, plant that seed in the jury's mind that there is a concussion involved here.
Please do not get into the facts of the case.
I'm not gonna get into the facts of the case, but I do believe that the SFST, the manual that the officers read from do tell them that they're supposed to check for these things. They're supposed to
And
ask
yes,
for EMS.
I'm not disagreeing with you. In trial, on direct and on cross,
I
yes.
believe it's a proper voir dire question
That's
if
improper.
You-
Voir dire is talking about the law, what the law is, and getting their opinions on the law, not telling the jury what you believe the law should be or what you believe are relevant and issues to this case.
I'm
So that's why we're
not-
arguing with improper voir dire when it comes to the concussion, because you're implanting to the jury that a concussion is going to be involved in this case, and you're going to provide opinions as to how that might affect the SFSTs instead of letting the jury provide their opinions, what can cause issues. You're providing them with the law, that your interpretation of the law, and that is improper voir dire. That's not, you have to give them the law and provide their opinions in regards to the law. It's to determine whether or not they can follow the law.
And Your Honor, I believe it's very easy for me to stay away from me mentioning it, but if I have a juror that knows who that is and mentions something about a concussion or anything, that's not a problem with me. I have the ability to voir dire on whatever I want to voir dire on, as long as it's not the specific facts. And I believe the protocol that the officers are supposed to go through, what they're supposed to check for, the things that they're supposed to ask and ascertain prior to SFSTs or getting these sort of results, is checking people for concussions or head injuries of any kind. And so I believe if I ask anybody, hey, who likes college football, and who knows who this is, and why could something like this be important to a case? I don't see that there's any issue with that, Judge.
Okay,
Judge, if he points out a particular football player who had a concussion and issues, that automatically puts that seed in.
And as you said, we don't
okay,
have.
hold, stop. I'm gonna sustain it as far as just as the concussion is concerned. If you want to allude to something, but don't start suggesting it, please. Please do not get into the facts of the case. Get into the law, generally speaking, with DWIs and just like everybody else when we try a case, okay?
Judges, based on his comments, we're also gonna ask in motion only that he does not talk about what the law enforcement is supposed to do, or their manual, or SFSTs. That's more of a fact issue. That's something for the jury to determine the credibility of the witness when they're on the stand. Not to start talking about police officers have a manual that they have to follow and all these things. That's not a legal issue. That is more of a fact.
It's getting into the facts of the case as well.
Your Honor, that's as general as it can be. Every single case has those same general protocols.
I've been trying cases for 25 years. Never in 25 years have I ever heard someone get into the manuals in voir dire.
And
I'm telling you, it's just.
that may be those people, but I don't plan on asking those specifically saying manuals, Judge. But I do think I have the right to ask the jury how they think a car crash could affect someone, what type of things happen after a car crash, what should we be looking for?
Mr. Burnett, I would like to try a clean trial. I don't want bickering back and forth. I don't want pushing at the boundaries. Please, I'm asking you, make it a clean trial, okay? You know how to try a case. You've been doing this quite a while. What you can and can't get into in voir dire, I'm not asking much. I'm only asking you to follow the law. Please.
Plan on doing it.
Okay, don't get into the manual. Don't get into this. This is stuff that happens when you're on direct and when you're on. Okay? Anything else?
Judge, do you want to address the defense's motion in limine while we're also?
Yes.
I was intending on addressing it, which one I wanted, Judge, but.
Is anything
I
related
have
to
a few
voir dire?
others. Nothing to voir dire.
Do you have a problem with any of his limites now? Have you seen?
I was under the impression just to get jury.
Yeah, if that's fine. If you want to do it tomorrow, we can do it tomorrow
That's
as well.
fine, Judge. We can do it tomorrow, since he's
Okay,
thinking that.
I guess take a look at them to see if you have any problems with any of them.
Yes,
Do you have any other motions that you want to file or that you want to
There'll be some more.
More? Okay.
I don't see any orders, Judge, so, because that's the last one I was able to check what we agreed on, didn't agree on, but I'll just circle whatever we don't agree on.
Okay.
Yeah.
Okay, panel should be here any moment.
Thank you.
Okay, hi.
Your Honor.
Morning.
Mr. Trahan, Your Honor.
Okay. Where are we at with Mr. Reagan?
I feel it's a great trial case for us. Do we have everything? Sorry. Don't step to the side.
No, let's take care of it now. Do you have everything? Are you missing anything?
Recall, everything seems to be complete from what I can see. 911 is in.
Wonderful.
Yeah, everything's in.
Okay, do you have an offer on the case? So we'll give you another reset at the next setting. They got to be here to let us know what they want to do with the case. Victoria, bottom of page 22. 30 days must appear clear trial. All evidence is in and offers made. Please.
Have you seen her?
Thanks. Have a great day. Hi.
Good
morning.
I've got, two of them set for trial. Victor Gonzalez and Marlene Alvarez.
Let me see. Gonzalez. And who is the other one?
Alvarez.
Oh, no, so he said.
Okay. Pick 30 to 60 days. We're in trial on another case now.
All right, Judge.
So we'll just reset you 30 to 60 days.
And then I've got one, Wilson. That was a writ Eddie.
It was a what?
A writ Eddie.
I'm gonna double check.
It's 222 days. I'm not,
I'm playing that up, Judge. So Judge, let's say we spoke to them in January, but they didn't get any estimates or information. So that's what we followed up on and we did not get an answer. That's the voicemail.
so cut it loose. It's 222 days. It's not,
You have to confirm because it is a criminal offense, whether or not there was any restitution. If you can get one more setting to.
no. It's 222 days. It should have been done way long ago. It's over.
I can make an offer to not include restitution, Judge.
Right.
Okay.
So we'll give you up until next week. Your client's got to be here at some point next week to take the case, either accept it or we'll set it for trial.
Okay, so we'll come back in a week on this one.
Yep.
We said the other one for
Yep.
30 to 60 days.
Okay. Hi.
What about for council, bottom of 3?
You have another one. Caldazo,
Yes, that,
Cadalso.
For the email, they were working on mitigation.
yes, that this was tried out. I'm gonna confirm that.
Please, it's 170 days old. If you need a reset, it's only going to be a couple days around.
And then the last one, I guess, was Davila.
That was at, bottom of 3, he has 2 different last names.
Oh, okay, okay.
Got it.
So that's what that is.
I'll work on it.
Discovery's complete. On that
Yes,
one?
Judge, discovery is complete. Everything is in photographs and everything. like
Great.
that.
Okay. Do you have offers on the case?
Not at this time, but I will get with the judge.
Please,
Yes.
at the next setting, which is about a week, clear trial. So if you want to submit the mitigation, do it within the next couple days, please. Okay.
Then top of 4, Judge.
Ay, caramba.
Yeah, he had one.
Same thing. What do you want to do with Calvo? It's 180 days. It's a
I'll
DVR.
work it out. That's what I'll do.
Okay.
After you said it a week, I could try to do that.
For
Well, that's what we're gonna
the
have to
email, for
That
the
one has
email,
an
a supervision order was to be filed today.
For Chicago?
Yes. From the office.
Did I just have one?
Application was submitted on 8/11, approved. The TRAS was done on 8/11.
Contract was received August 21st.
Wait, I sent that, hold on. For Chicago, I see that the contract was sent to Fence on the 21st. Right, we have not in fact. I don't have it back.
What's today? Tuesday?
When I know he gets his
Yeah, so 4 days ago, Judge. It looks like contract was sent 4 days ago to defense. He did pay the DA fee. I just don't have the signed contract back to do the supervision order.
Or the interlock?
The defendant is here today.
You want to check with him to see if he's got the interlock installed? If not, we'll give you a week. If he doesn't have it done in a week, I'm rolling him day for day.
Because all they said is
Okay.
contract was sent to the last note and then he paid the DA fee.
Okay, thanks. Are you ready?
Sure.
Hi.
Just on Mr. Roberts, receptor files today, obviously, I don't know.
Yeah, just, I guess, set it 30 to 60 days. Thanks. Hi, Mr. LeGrand. Hey, what's up?
I have a couple of, but I think only one's on your list. It's Mario Davila.
What is it?
Mario Davila, it's another Davila. And he's been approved for PTI. His TRS is set tomorrow, but he's here today.
He's sitting from Mr. Original.
Perfect.
Oh, great.
That's what I was gonna
Okay.
ask for. So-
Yeah, we'll set you 1 to 2 weeks to finish it up.
Okay.
That's all we're waiting for.
Yes. And then I have,
Ready?
Tara Richardson. I don't, we filed the application. I don't know if she's gonna review it.
Oh, Judge, on Leslie's 2 cases, we sent them together.
Yeah, so I said 1 to 2 weeks
So I
to
can
finish it
present them
up.
both then?
Yeah, of course. Okay, you ready?
Yes, sorry, I didn't see you open.
Hi.
The person is fair. Fair, and T-I-R.
Okay,
For that, I'm not gonna do it for this whole weekend. There are no videos on it yet.
okay. It's 190 days old. There. Jury's here. Ladies and gentlemen, we have a jury here that we're about to bring in. If you're sitting in the middle, please, if you don't mind moving to the sides, we're going to utilize everything for the panel, please.
Oh, sorry.
Is he PD judge? So this one like, baffled, but I know it's from 2021. So I just wanted to double check before I saw the report. I know we don't have it, and it's not in our order.
Okay, I mean, I'll give you till the end of docket.
Yes, Judge.
If it's not, whatever's not in now, it's just not coming in. That's it. Okay, and then I'm going to give you a week to decide what you guys want to do. You're at 190 days old, so he's got to be here in a week to clear trial.
Okay. There's one more conversation.
All right.
Judge, for fair, we do have the body worn camera. I'm going to export it to the fence right now. To see if anything have been exported to the fire. We do have all the body worn cameras.
Okay, so regardless, still, you got a week. Can you put offers on it, please?
I think they might already have. Yeah, she already has offers. Judge.
Okay. Hey, Victoria, top of page 7, 1 week clear trial. Yeah. We're going on the record.
And Your Honor, sorry. Your Honor, I'd hate to make this request, but my subpoena for the one officer that I mentioned, the state did subpoena yesterday, my subpoena just came back unexecuted. This is a material witness as a material witness as it gets. I need that officer. I would hate to ask for a continuous judge, but I do need that officer.
Judge, she no longer works for Metro PD, that's, and I did inform counsel when we were set for that motion to suppress hearing, that they no longer work at the agency. I never received, like, I need this person, so we can try to have locate and serve them. So that's the only thing I can say, is they don't work for Metro PD. If I would have shown that we wanted this person, we would have had a location for our investigators to try to assist him in trying to locate this person, but we were not planning on calling them.
Your Honor, they were.
I mean,
That
This case is, I've got a jury outside.
I understand that, Judge. And I thought that the subpoena would come back, and I also tried to find. I had an investigator that was trying to find her and the other two people, but I did let the state know that I needed.
You asked for investigator funds, which I granted.
Yes, to find those other two individuals, and I asked my investigator to find her as well.
So tell me, what has the investigator done then?
They have not been able to find out the person. They've been searching for them, but they have not been able to find them.
I understand that.
Yes,
What have they done though? We've given them money to go do work. What have they done in the 3 weeks?
they've been searching. They've been trying to find them.
Where's your investigator now?
They're not here today, Judge.
What's your response?
Judge, the state does not intend to call them as a witness. They've had time to locate this witness. I know they're no longer with Metro PD, and I did advise that they're no longer with Metro PD to defend, so they were aware of this when we had our first setting. So this is not any news to me. He's still announced ready for trial, so we're ready to go to trial.
And Your Honor, I will say that they did represent that they would subpoena this person and get them to get it. I made that known to you yesterday and the week before. I've tried to find.
Did you ever, I mean, I don't think that they ever said that they were going to subpoena the person. They've been saying since day one that they don't want the person, that they don't need, or they don't need the person.
That's not true. It's just actually not true, and I was told.
Judge,
just
I
right there
messaged
that
him
they-
on July 27th. I have these officers listed in the office report. Please advise if you know anyone else office wise. And I did inform him, Ms. Jornet was a student and no longer with Metro PD. I did not get any response in regards to that besides the two other real witnesses that are in the accident report. And let me make sure that those are all the names. This is when we're trying to figure out who he needed for the motion to suppress and for the motion for speedy trial. And at no point did I indicate I try to locate these people or anything like that. I believe that's what he got investigators funds to try to find this person. We did not intend to call them. We intend to go forward with trials with the witnesses that we have. He's been pushing for the speedy trial for it to go.
What is this witness going to testify to?
This witness is going to be able to testify to the real witness's statements to her. She is the main officer. There are other officers that spoke to the real witness, but she is the main one that asked and questioned them about operation, Judge. And she's as material as it gets.
Is she going to testify differently as to what?
It's not hearsay, it's present sense impression. And there's other.
But do you have a real witness as well?
We spoke to the real witness judge in regards to coming to testify. So they're going to subpoena to come to testify.
Is it a civilian or is it an officer? And are they coming?
They have not confirmed with me that they will come. Not one of them did not answer my phone calls. The
Be
other-
careful what you wish for, Mr. Burnett.
I would like them to
Be
come.
careful what you wish for in this life.
I would absolutely, and Your Honor, I had not been provided with that information, but I would ask that we send somebody out. I would ask that somebody go bring them in. I would ask that we send.
What do you
somebody-
mean, someone to bring?
I
who
would,
in?
I would ask that we send an officer to go and attach them to this case and bring.
You don't have a duly executed subpoena to attach a witness
I
to.
actually do know subpoena for those.
Okay,
Judge.
okay. You don't have a subpoena that's been executed to attach.
Not executed, yes. Judge,
Right.
but,
For the two real witnesses, I do, but not for the office.
well, she's got them.
How
she's got
long of a
them
reset do you want?
As long as it takes to go and attach them and bring them here.
You first need to have a subpoena.
She says she has a duly executed subpoena for those witnesses. Judge.
Let me double check.
That's what she said.
Judge, in regards to the real witness, I'll work on with our investigators to try to get them to come and speak to them to make sure they understand they have a subpoena and they have to be here. There was one that did not respond, so we're not sure if we have the correct information for that one. We know that it was executed, but we don't know if that person still lives at the location because we went based on the information that we had in the office report.
If this person has moved out of state, it's moot.
Correct. So that's what we can't confirm, Judge, in regards
You
to the
know?
second bill.
Well, we can't decide that they have just without checking.
How soon can your investigator look into see?
They're running the panel now, and then I can have them do that, switch from the panel to that. And I can have other investigators in our office focus on that, Judge, if you allow me give me 10 minutes to call.
Yeah,
maybe a
okay.
little less.
Stand down 10 minutes. Let's see where they are.
Yes, Judge.
Because if they're out of state, then we'll just go forward. You know,
Yes.
if they're, local,
Yeah.
then we'll cross that bridge when we get there, I guess.
Yes, sir.
All right, let's stand down 10 minutes. Okay, thank you for being patient. You ready? Okay. If he doesn't have the contract here, I'm gonna roll him until tomorrow. Your case is 220 days old and all he needs to do is get the contract. So we can just roll it.
Contract was received August 18th.
Oh, the contract was already.
Yes, received this.
Oh, he called me. He informed me that he dropped it off on Friday. But I wasn't there on Friday. Nobody has given it to me, so I need to.
You wanna call them to see if they have it? Maybe they can get it to you now and they can. Or do you want to roll till tomorrow?
I think we'll need to.
Okay, roll it tomorrow.
Judge, I am gonna ask for admonishment, just because I'm looking at it as a note from intake prosecutors. Just to indicate that the defendant was pulled over on 8/19 with a handgun in his vehicle and violated his bond condition. So I would just ask for an admonishment since he was entering the DWI PTI. I don't.
Do we know?
He wasn't charged or anything like that. It's just what intake had informed me in regards to him having a firearm in his.
You have bond conditions, Mr. Lee. Excuse me. If you violate these conditions, I'm going to throw your butt in jail and everything that you've worked for now will be for naught. Have seen more denials of the PTI program because people have bond violations than ever before. Do you understand? Take a seat for me. We'll roll to tomorrow, please. Okay. I just keep me in the loop if
Yes,
you,
Judge. They didn't file any additional charges. They just indicated they got a call. So that's why I just wanted to be admonished. It would have been your
Judge,
call.
for tomorrow,
yeah, I think.
sometimes.
It's 220 days old. Do you have anyone else?
Yes, Mr. Lynn in.
Lynn, okay.
For him, he submitted his,
Mitigation,
yes.
okay. Any word?
I don't.
No, they have not. I haven't gotten it yet.
Okay.
To us, Thursday or Friday.
It's 160 days. I'll set you a week again. He's got to be here. Is he here now?
Yes,
Okay. Do you guys have the mitigation packet?
yes, he said today.
Okay, great. So we'll give you a week and then I guess we'll go from there.
The next one is Mr. Simon.
Okay.
For that one,
Is Mr. Simon here now?
no.
Also a week to do a TRAS for Mr. Simon, bottom of 20.
Judge, he's one of those that's, food is not vaccine or one of those foods, so it's gonna be a 1 year PTI approval, so he can get a TRAS.
Are you approving it?
Yes, Judge.
Okay, great. So we'll set you off also a week. He's got to be here to get the TRAS done.
Yes, sir. Last one is Mr. Valdez. I did not check it with the clerk yet, but it's a motion to withdraw. We came in before, I think the day you
Oh,
were.
let me see how old it is. If it's old, I'm not going to grant it.
Okay.
It's 190 days old. I'm not granting your motion to withdraw.
Okay.
Is Mr. Valdez here?
He is.
Mr. Valdez, come up.
He's an interpreter.
Okay, just give me a second. We'll get an interpreter then. Does he have the application done?
No, he doesn't.
Okay, he's been working on it for about 3 weeks. We'll also roll him to tomorrow to get the application done. And we'll go from there. Okay. And let him know that if he doesn't have the application done, he'll come back Wednesday, Thursday, Friday, and then
No, I always use that one. Yeah, just trying to.
thank you. Hi, son. Hey,
Judge, I have Silva for docket, Angela Silva.
okay.
She picked up a new stuff from Judge.
Yeah, I saw that.
Yes.
I'm gonna revoke both of these bonds. And Silva. So she's on bond with us for, first she picks up a mischief, then she picks up a theft, now she's picked up a UMV. I'm gonna send them both at 5,003
Each.
on our cases. Yeah, each at 5,003, and then we'll see if she bonds out.
Same bond conditions?
Same bond conditions.
Thank you.
Yeah, yes, ma'am. Thanks. Hi.
Yes,
Ralph.
Richard. I got Mr. Pavel. He's complied with everything, Judge. He actually beats the eye.
So are you ready to file the supervision order?
I give it to you right here. He's got the fee paid, the interlock, the terrace completed, and the application.
Where's the contract?
It's right here.
That's not the contract. The contract's completed.
That's it.
Oh.
See? Yeah, that is-
Yeah, I know that we need, and then.
That's it. Yes, no, my fault. Thank you.
Okay, the defense needs to sign, Judge, and then he has to swear with the clerks, and then we can get this done today.
Wonderful.
Okay.
He needs to sign it, swear to it, and then we're
I got
good.
lucky, Judge.
Go play the lottery.
I think I got lucky.
Go play the lottery, Ralph. Are you ready? Thank you.
I don't know how it all fell together, but it did.
It did? Hey, that's okay. Are you ready?
Yes.
Thank you for being patient.
I have a anomaly.
Oh, I'm sorry. We've been so preoccupied.
Thank you.
I'll sign it right now.
Yeah, that's for Mr. Kirkpatrick.
Okay, I'm signing it right now.
Thank you.
Thank you for being patient.
My
Okay.
pleasure.
Hi. Craig, you ready?
Yes, sir.
Hi,
Good morning, Your Honor.
good morning.
So Mr. Pansky's husband, posted bond for, but I believe she's still in custody at this point, Your Honor.
Okay.
She was on docket today.
They always roll it to the next day as a fail-safe, so,
Yes, sir.
um,
So as soon as she gets out, I'll
Hey.
have her.
no. So she needs GPS prior to release
She has the conditions.
and then home confinement. Okay,
Yes, sir.
yep, all right, thanks. You got it.
However soon we can get one is fine.
I would do it, yeah, ASAP.
If I can get one, I'll speak. to her.
And then obviously, hey, Veronica, she can leave for purposes of the TRAS, then she's got to go right back home. Okay, okay. Thanks.
Thank you.
Omar, hi, thank you for being patient.
The case that I put on yesterday, so I get attached to, I was never attached.
I don't even remember you coming yesterday.
No, I zoomed in.
Oh, my God,
and it
that's
said-
biggest.
I don't even, did you zoom in yesterday?
No, it wasn't yesterday, it was last week. I zoomed in and he said, put the customer in the chat. I heard you tell the clerk to.
It must have been an oversight, I'm sorry. We've got a lot of drama that goes around here, man. I'm so sorry. I will attach you right now.
Mothers.
Okay,
No, tell them no.
do you want to let them know and then they'll put it in the queue now,
Yes,
please? Sorry about that.
no problem. Yes, please.
Okay, what's the call?
262.
Hi, yes, of course. Hi, good morning, Ms. Bell.
I'm gonna be really quick. I've got a trial case on docket for Tuesday. I have a call number, can you just want to give you a heads up? It's 259-68.
25968.
I'm sorry, 259-6856. It's Guillermo.
Gonzalez, okay?
Yes, that's right. You know, I'm starting trial on Monday in the 180th. I just want to give the court a heads up. I didn't know where we were.
We'll hold it. If you're in trial, obviously we'll reset it and we'll go from there. Yeah. Because some, you know, a lot of times your cases up there don't even go, whatever happens, but.
I'd rather be here than.
All right, great to see you, Mr. Vale. Hi, Connor. Oh, hold on. Kobe's been waiting. You just got here. Kobe.
Hi, Judge.
Can you hear me?
Yes, I can hear you. You can hear me.
Shh. Okay. Who you got, buddy?
I have Miss Granberry, who she had a bond violation report related to the. She's the one who's living in Memphis, who was ordered to go to drug testing.
Is this from yesterday, right?
No, that was we had a lady that was on docket yesterday. We dealt with that.
That's someone else.
Yeah, so Miss Granberry, she's not showing up on my docket today, but you had ordered it to be put on the docket, and they had ordered her to be here. And
I don't see it either.
Yeah, I think she's there.
It was ordered via email. I'm not sure if it was placed on the docket.
What is the cause number, please?
It is 261-9676. And she did test this morning and tested negative.
So Judge, if you remember, this is the one I'd emailed you. I had sent her to get a rapid test somewhere, and so we had sent you the results kind of the day or day after she'd been ordered to do it. I guess we probably hadn't communicated well enough with the court that she was in Memphis, so it hadn't been set up for her to be told to go to whatever the testing out of town was.
I don't even see the bond violation report filed electronically.
She did not get a violation because she's on a summons and not a bond.
But she has 4 other bonds. She's got 1, 2, 3, 4, 5 open cases. They can't do it on the other 4 that are open?
I can check with the office.
Please, that would be great because, you know, paper for everything, you know, publish or perish, you know? So from now on, please, because you can see the kind of snafu and the kind of problem it creates. Okay, we'll continue supervision for now, Cobe.
Okay, thank you. And I think the state had been, we had just had a court setting, so they had been doing an eval to try to figure out where we were headed.
Okay,
with all this.
do you want to keep the 9/3 date?
We'll keep that date, yes. Judge.
Okay, all right. This is Granberry.
Yes,
Okay.
Judge.
Yeah, she tested negative today, so we'll continue supervision. And then we'll just keep the original date of 9/3.
Okay, just a heads up.
Okay, it'll be waived.
Yes.
Okay. Okay, bud.
Thank you.
Thanks.
Thank you, Judge. Yes, sir.
Have fun.
Do you want to amend the conditions to allow her to test on the months?
Yeah, that's okay. Yeah, but on the other 4 cases, please. Okay. Connor.
Hi, Judge.
Hey,
Yesterday on the case.
I remember.
She's here today.
Oh, is that the arraignment, Victoria?
No,
I don't think so. It's
Nope.
Gomez Lopez.
That's not you?
I don't believe so.
Okay, what's your cause number?
It is, so the case that is open right now is 262-8144. Maureen Jordan.
Okay. Can you give me 2 minutes? Just give me 2 minutes. I need a call.
Yes.
Alvarez.
Oh,
Did you find that motion?
Because I've got like 3 different ones. Which I don't, it doesn't show up. What's the last 4 of that one?
All right, go ahead and sign here.
Okay, got it. Okay, let me step up.
I mean, I would have. Especially
This role was much more self-sufficient. The first role, the eighth floor. They were. I sort of plan part.
It's actually, like, whoever's machine came in, it doesn't matter. There's no impact. I knew you think you could send it, like, I don't know. I got it. But it's like, your phone, what's in your sugar schedule? It's like, why is there 80 cases? Central other cases.
It's just
But I can share my.
All right, so
Yeah.
Just 18 months.
That's all.
Okay. So for snow, it's again, state says discoveries and then we get first part of the. So you might have everything from also.
Are you ready?
It's good.
Every time we go to the family, we have to have a choice.
Right. Okay. Certainly.
Coming back first.
That's assuming that she's flying. Okay, got it. Thanks. Okay, bye. Okay, Connor, sorry.
No problem.
Any luck? Michelle, any luck on the witness?
Yes, so, one of the witnesses,
No, not his.
yes, both of them. Should I talk to them first?
Council, you ready?
So I called both, I was able to get in touch with both of them. One said that, he'll be able to come, but he can't be on call.
Who is that one? Your witness,
The wheel witnesses.
right? But I'm more concerned about his witness.
Both of them
If
would
the will
technically
witnesses, that I'm looking to get their statements in, I'm gonna try to bring it in through the officer, so if they can come, that's even better.
But what if they don't?
I would like them to come, and if she has a duly.
You know how that
attached-
works? I want hair. I'm not gonna get it.
I understand, but if she
I
has
just
a
want to
duly
point out that
executed
he has
subpoena.
requested a speedy trial and has waived all notices and has waived everything in regards to subpoena stuff. And we have been bending backwards to make sure that we're ready for trial. So he's making demands. We looked at the subpoenas for the wheel witnesses. They weren't executed, unfortunately, because of the short time that this was set. So we contacted them. We're gonna try to get them here and do our due diligence to try to get them here because that is our job. But him making demands to attach someone that wasn't properly subpoenaed is improper. And, you know, he needs to understand
The
that.
state,
We have a duty and we're trying to comply
and
with our
the,
duty,
and the
but our,
state's told me that they just said. up
Do
here
you
that it
still
was
want a
duly
continuance?
subpoenaed.
Yes
I
or
would
no?
like it if I can be able to either get them here or to be able to get them, and
But there's no guarantees in this line.
I understand there's no guarantee, but first of all, I do think this witness was a person in a car crash. There should have been a rip call.
So,
This was
well,
discoverable
Mr. Burnett,
information.
Do you just want a continuance? If you want a continuance, I'm giving you 14 days,
Yes, Judge.
but that's the last continuance.
I
You will be
understand
prepped set for 2 weeks from today.
Can we ask for this information to be released to us because it is discoverable?
do you want to go on the record, Joe?
And I'm not here in 14 days, I'm in a seminar.
When are you gone?
I'm going the 9th through the 11th. I'm in a seminar.
Okay, so I guess let's do the 15th. Okay? I need you to file a motion for continuance.
Judge, you want?
You said the 15th.
Yeah, hold on.
Judge,
Guys, we're going on the record. I'll let you make your argument. We're back on the record in cause number 2610088. Defense has subpoenaed a witness, asked for funds, which I granted on 8/13. We're set for trial today. I've got a jury out there waiting. And he's just come up to say that the subpoena came back unexecuted. He is saying that this is a material witness for the defense and that he initially asked for continuance. State, what's your position?
Judge, we will be opposed to the motion for continuance. Defense has requested a speedy trial. We have been able to contact the wheel witnesses, which is the statements that he wants to get into during the trial. One of the witnesses just needs to confirm with work and can make arrangements to be here this week for trial. The other one says they will be available to come and testify on Friday for trial. So we're trying to coordinate their schedule. If the court would like to coordinate with their schedule, or is able to, then we would ask to go forward and we're opposed to the motion for continuance. I will like for the record to note that their subpoenas were not executed due to how quickly the trial was set.
First, on the issue of the material witness, this person has exculpatory evidence from our client that is
Your witness.
my witness, yes, and I believe the will witness as well, because it was their statement that I was going to attempt to bring it to them because my investigator had not been able to find the will witnesses. I went to their addresses myself personally before I even asked for the investigator or the addresses that were on their licenses at the time. On top of that, Your Honor, I would just say, I believe that these will witnesses who were part of a crash, who technically would have been victims, any conversation should have been discoverable and should have been released to the defense, phone numbers, things like that. So we could have actually prepared for them to be here. We're never informed that they were able to make contact with them. We did ask the state to subpoena all witnesses. They told me that my witness, Janae, did not work at the Metro HPD in the email. Did not say that they would not subpoena her or try to get her here. And that is the reason why my subpoena in a short time was not able to get executed. But I was under the impression that the state was going to subpoena everyone. So that is the reason why our subpoena was late in time because we noticed they had not done as they had told us they would.
Do you want the continuance? Yes.
But I needed to make the record clear. But
Yeah. I get it.
we would like the continuance, and we would ask that those RIP calls and that information be shared with us, so that way we can try to ensure that these witnesses can be here and schedule a time.
What's your response as, not for the continuance, but what else he's asking for?
In regards to the call, Judge, we will disclose any conversation we have had. The third's duty is to disclose any Brady information. The phone numbers for these witnesses were in the office report and the information that he has had throughout the trial. He also has subpoena power to subpoena these witnesses if he believes that they are material to his defense.
So everything that he's saying is in the offense report?
Yes, Judge.
Your Honor, I've called both of those phone numbers that are in the offense report. One was, the phone was off, and the other one.
Well, but they don't have a duty to continue to look for phone numbers. I mean, whatever's in their possession is okay.
And that's the
Yes,
phone
and I'm
number
not sure that they're using the same number.
That's the phone number we reached them at.
Okay, I need you to file a motion for continuance. I'm gonna grant it. You will be preferentially set on the 15th of next month. We are going, regardless, it doesn't matter. I would probably get the subpoena out now
Yes, sir.
so that there are no issues in the future, but there will be no final continuance in this case.
Yes, sir.
Judge, in preparation for this, I have contacted most of the witnesses. I'm gonna double check the emails in regards to any conflicts they may have had. I can inform the court that.
Okay, well, that's a good idea.
Yes,
So,
because I did contact them for all of September to see if they had any conflicts. So I'm gonna go through my emails and I will advise the court in advance by the end of the day if there were any conflicts.
why don't we regroup tomorrow morning?
Yes,
So that we can finalize the actual date to make sure that your witnesses are good and then get your subpoenas out, but this is it.
Yes, sir.
There will be no final. Okay,
yes, sir.
all right, anything else?
That's it.
Okay, do you mind releasing the panel, please? And, Mr. Burnett, I need you to follow motion for continuous second grant.
Yeah.
Please. Okay,
Counsel.
cut it loose, please.
Counsel. I have.
Hi, Connor, you ready?
Yes.
All right.
I'll call you up next.
Marnie Jordan, come up. Oh, I'm sorry, Blossom, I just saw you. Do you need a translator?
No.
Okay, Blossom, I'll hit you up next. Sorry.
Counsel, your clock is fixed.
You were, Miss Jordan,
You need someone to sign when you have a seat. He has several petitions that he has to come up to sign. His signature. All right, go ahead and sign, please. Go ahead and slide over.
yeah. All right, Miss Jordan, so she's on bond for theft.
Yes.
On 7:30, she picks up an organized retail theft, which is discharged,
Yes.
and now she's picked up another case. Now you're charged with false report to police officer.
Yes.
Right. On that case, ma'am, you are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, ma'am. False report.
Yes, sir, I have here. Officers, the defendant reported that on August 15, 2026, her rental vehicle had been struck by an unknown vehicle in the E. Terry's parking lot located in Bridgeland, Harris County, Texas. Initially, she provided deputies with a statement claiming that an unknown dark colored SUV backed into her vehicle and left the scene without stopping. The defendant stated that she was not at fault for the collision and wished to pursue the charges against the unknown driver. On August 16, 2026, the defendant contacted dispatch and requested to speak with the deputy in regards to a subsequent telephone interview with that deputy. The defendant admitted that her initial statements were untruthful. The defendant stated that she initially provided false statements because she did not want to be found at fault for the collision. The defendant admitted that the collision actually occurred while she was traveling behind an unknown vehicle, which was stopped at the stop sign located within the P. Terry's parking lot. The defendant stated that she struck the rear of the unknown vehicle, causing the damage to both of the vehicles. That she admitted that she was at fault for the collision and had falsely reported that the unknown vehicle had struck her. She said she was scared and didn't know how to handle the situation.
Does Ms. Jordan have a license to drive?
She's valid.
Just to make sure.
Let's make
So that it is
sure.
eligible, then yes, it's valid.
All right, ma'am, I'm going to find that there's probable cause to go forward with your case as a condition of your bond. I'm ordering you not to have any contact with the complaining witness in this case. You are not allowed to drive unless you have a valid Texas driver license and liability insurance in your name. If you violate these conditions, I will revoke your bond and put you in jail. Do you understand? Okay. Now, she's on bond for a case. She's now picked up a new case. What should we do on bond? Are you here with a bonding company?
There is a bondsman here, yes, sir.
What's your position?
Your Honor, considering that this is the second new law violation that she has picked up law on bond, state would ask to go for bond and to double it.
So Judge, a couple things, the organized retail theft was no PC and it also included partially this underlying theft, so it's.
What do you mean partially?
Because as a part of the allegation included the theft itself. So was going to say like this, a theft from here, a theft from here, a theft from here was the aggregate. But that was no PC. And then also, and I know doesn't go to PC, but she did make the report, or she said she made the report, and then she called the officer, tried to right her wrong. She showed up here today on her own volition.
I appreciate that. So, but I nevertheless, she picked up a new case.
Yeah.
So what I'm going to do is I'm going to set both of your bonds at 2501, but I'll allow her to go with a bonding company now because she came in.
Yes, sir.
Ma'am, if you pick up a third case, I'm going to go bananas on your bond. Do you understand me? There's no excuse. There's no more tolerance after today. Do not pick up any new cases. Where are the thefts from Walmart or
HEB, Judge.
both?
Yes, judges.
You were not allowed to go to any HEB whatsoever for any reason. Do you understand? Let me see if we have bond conditions on that.
We do, Judge. No HEB. I think was the biggest.
Yes, Judge, there's
Yeah.
no HEB.
Okay, all right. So what I'm going to have you do is I'm going to have you take a seat in the jury box. We will have bond conditions created for you to sign. Once you sign and the bonding company is here, then we will release you today.
And Judge, for the bond conditions on this new case, you mentioned no contact with complaining witness. I don't know that we have a name for.
That's correct. I was gonna say, Judge, we have the complaint.
So there's no accident. It was
There
just
was
a,
an accident, Judge, but there was no accident report ever done because they didn't know the name of the other driver in the vehicle. So there was no listed influence. I just did no driving without a project.
and like, an insurance then. Yeah, yeah. Okay. All right. Thanks.
Thank you, Judge.
So don't worry about getting a setting.
Okay,
Because once she posts bond, she'll get a 7-day setting and then just feel free to reach out to Victoria and then we'll,
sounds good to me. Judge.
okay?
Cool,
Thank
thank you.
Here for the off document.
Okay. Sorry, guys. Let me just do this around
Thanks so much.
Lopez, Gomez.
on both of your cases.
2501 and I'm looking at
Okay.
keep the old one the same.
No, both of them are 25. The new case and the false report and the theft. The organized retail, it's, no, there's no PC. So it's, what was the last thing?
Lopez Gomez.
Is it on docket or not?
Off docket. Is it off docket?
Is it off docket?
Yes, Judge, I have the case number. You ready?
Yeah, yeah.
263646.
All right. You are Miss Lopez Gomez.
Yes.
Ma'am, you were charged with assault causing bodily injury. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
Officers were dispatched to Houston Thompson Hotel in Harris County, Texas, in reference to an assault that just occurred. Officers met with the complainant, who indicated that she is a supervisor of that location. And the defendant arrived at the lobby. She was detained when the officers met with her. Complainant stated that she was alerted by staff that the defendant was on the 7th floor bar, highly intoxicated and causing a disturbance. Several staff members went to address the defendant and tried to escort her to her room. Initially, the defendant had gone to her room with the staff, but then became hostile and returned back to the pool area. Complainant had stated that she had tried speaking with the defendant again, but the defendant became aggravated and slapped her twice in the face on the right side with an open hand, causing pain, and that she was to suppress charges.
Ms. Lopez Gomez, I'm going to find that there's sufficient probable cause to go forward with your case. As a condition of your bond, I'm ordering you not to consume alcohol, illegal drugs, or unprescribed controlled medication. You will be randomly tested. If I find that you're using, I will revoke your bond and put you in jail. There will be no more PR bonds for you. You understand? I don't know what your immigration status is, but if you're not in this country with permission and you go to jail and immigration finds you, they may very well put a detainer on you and you could be stuck in custody for a very long time. You are not to have any contact with this complaining witness, not to go back to this hotel, and not to be in possession of any weapons. Do you understand?
Yes.
Do you have a lawyer, ma'am?
No.
Do you have the ability to hire a lawyer?
Yes.
We will give you time. I'm going to have you go sign a reset. We will have you meet with Veronica for your bond conditions, and after that, you'll be free to go. We will see you back in 30 days. When you come back, please have a lawyer.
If I can't return because I don't live here.
You have to return. If you fail to return, I will issue a warrant for your arrest. You have a criminal case. Your presence is required until you have a lawyer. At that point, we can discuss about waiving appearances, but at some point you may need to be back. Until you have a lawyer, your presence is required here.
Okay.
Okay, thanks.
She said she was going back to Mexico, so for the random testing, you still want to look for.
I'm ordering her. I'm ordering you not to go back to Mexico at this time. You have an open case. If you go back, I will issue a warrant for your arrest. So let's do this. You need to first talk to a lawyer and then we can go from there. But if you go back and you don't return here, I will issue a warrant for your arrest.
Can I go with that?
That's, I cannot give you legal advice. You need to talk to a lawyer about that. A lawyer can give you legal advice. I'm just warning you, you were on bond for a criminal case. For the time being, your presence is required back within the next 30 days. If you fail to return when you're supposed to, like on the reset, then we will issue a warrant for your arrest. Okay? All right. You also, you are required to undergo bond conditions and testing. If you fail to live up to the conditions that we have set, then likewise, a warrant may issue for your arrest. You are required to periodically come and do drug and alcohol testing. If you fail to show up on the day that you're required, a warrant may also issue.
But I don't understand.
Then talk to a lawyer. A lawyer can help you out. Please.
Right this way.
Thank you for being patient. Yes, Ms. Cook, come on.
It's all right, my need to zealously advocate just.
That's okay, really. I wouldn't expect anything less.
I'm seething with it.
Yes.
So
We need someone brought out.
Regarding Tyrone Joseph Jr., he's off docket reset for today.
Okay.
The state is asking for an extension. We talked to South Carolina. They're unable to pick him up until 9:15. He's.
This is opposed to this.
No. I'm with you. I'm not, no, that's, how fair is that? Imagine if you were in custody waiting and someone,
I
really.
understand, Judge. Here's the problem. We have talked and defense is not sure on whether the defendant is able to make a bond and get himself back to South Carolina to self-surrender.
That's, I mean, if they don't come within the prescribed time, I'm going to give him a PR bond. And will be directed to go back.
The number is one thing, but because they're fugitives, the PR bond I will object to because they're still statutorily fugitives. And so if the court decides to give them a low bond, obviously that's a separate issue, but he has extensive criminal history. And so whatever is persuasive enough to surrender, that I would object to.
Why couldn't South Carolina come to pick him up within the time prescribed?
Because with their means and resources, they can come within the 15 days, but they are emphasizing the 30 days statutory by law that they are allowed to do so. And so with the withdrawal waiver, if they can't make the bond, that's one thing. And we have up to 90 days to get the governor's warrant while he's sick. But that's what we're approaching it the way we are.
What's your cost number? Please.
263-5635.
So it's a failure to return rent, fraudulent application of $10,000 or more.
I believe it's the equivalent of a stolen car, but I had to refresh the case file.
Fraudulent appropriation, is that auto? I can't even read that. What does that
It was
say?
about 10,000. The way to categorize the thefts are different from our ladder, but it's, I think, if I'm recalling the conversation correctly, it's for a stolen car.
Shh.
So,
Yeah, I think that holding him that long is,
well, and like I said, if the court elects to give him a low statutory bond, that's one thing. Whatever number the court elects is reasonable for him to self-surrender. But obviously, even if, let's just assume it's $1. Even if it's $1, he doesn't have the financial means to self-surrender. He's still under bond. A warrant's gonna be issued out for his arrest and he's gonna come right back here, which is why we approached the way we did. If council believes that there is no number that can be listed where he can actually go back to South Carolina, then it would be in his financial and otherwise interest to keep it until the 15th and get a free ride back because the warrant's still in the air.
Let's
I
say,
think that, we tell people when they're arrested on each court, they sign that waiver, what they're signing. And, it's very confusing for them. And when we start waffling around like this, people just don't.
I'm on your side. I agree with you. So what do you want?
So I'd ask for a PR bond.
And like I
And
said,
then the alternative, I'd ask for
Can you,
$5
can
surety
you,
bond.
can you direct me to a place that says I can't give him a PR bond?
I will bring the code for the next part. He's not here today, and so obviously the other factors is I would want his means to actually self-surrender. Because again, even if it's $1, even if it's a PR bond, which I don't believe is statutorily permitted.
When is he set?
He's set for, well, he was set for a day, he just wasn't brought up. He's not in the holdover. So
Do we have too many people? Do you know why? Don't worry. I mean, it's just neither here nor
and
there.
so he still would,
You want to roll it till tomorrow?
that's fine.
Are you okay
But
with that? Can you be here?
I can be here tomorrow, but we also just, one, give a PR bond, or we get you a $5 bond. I have contact information for his family. I'm confident I'd be able to get a hold of them.
But regardless, I'm not going to set a bond until he's here so I can admonish him.
That's-
And
So if you want to roll to tomorrow, I'll take it under advisement, but also show me why I can't give him a PR bond.
I will look it up, but that's only half of it. Like I said, even if it was 0, right? He still has to have the means to self-surrender and the warrant is still live. So if he gets arrested.
Let me ask you something. Are these new cases?
No, this is an FTA, Joe. I believe it's an FTA. Yeah, failure to return. Oh, wait, no, hold on, sorry. I don't want to misspeak. I don't have to.
They're not new?
The warrants for 2025.
Yeah, it's been live.
Do you know when from 2025? Oh, okay. It doesn't matter. Dude's on probation for a couple cases upstairs
Right,
regardless.
that's what I meant,
So
because he has significant history here, and so obviously the concern, he's not the best at returning or picking up new offenses while he's on current.
Well, but I understand. And if we set him a bond and he fails to do it, there's a consequence.
Well, I think he's already had that multiple times in Harris County, which his record shows in Harris County. He's had that opportunity multiple times for other cases, but that's beside the point. Again, my emphasis on feasibility.
I didn't see any prior out-of-state fugitive cases.
No, I'm talking about the cases that he was on bond for picking up new cases and violating.
That's up to the felon courts to deal with that, man, not.
No, that's, Judge, that's not my point. Your argument on that was that for his compliance with your conditions, assuming that he's admonished tomorrow and he's self-surrendering. My point was that he has been admonished several times on other offenses. He's not great at complying with court orders. That was my point.
And I'll admonish him as such tomorrow.
I will bring up the statute and,
Okay.
and also ask questions
Thanks.
concerning the.
Nothing further.
Okay,
I'll
thanks.
see you tomorrow.
See you tomorrow.
Thank Judge.
Yes, ma'am.
8:26.
Hi, Sebastian.
Maybe.
Maybe.
Are,
I have council to go to,
are you, what about Velasquez?
That's one.
Okay,
Sorry, Velasquez, that's one.
got it. Okay.
So he has had a DWI, picked up a second one. He has an ice hold now, so that's.
Okay, I guess we'll just wait to see if you want to set it a week, 2 weeks.
I was gonna ask for 2 weeks just so I can.
Sure.
Discover and
Of course.
everything, get it with him.
Yeah, okay. Thanks.
Mr. Bell, that's the one that you did not, unless you took the job. We have to, transfer that right now.
Okay.
But
Blasa, can I borrow you for a second?
did speak to the client, he's saying that he doesn't recall anything about.
I don't care. He could tell me he's with the circus. I mean, really, at some point,
But there's.
Mr. Bellix.
There's also a language barrier, so I usually have to have somebody in the office communicate with them. And
Your case is 190 days old. This could have been done way long ago. Mr. Valdez, shh. just to give you a little perspective, we set cases for trial at 180 days. We cannot keep cases open forever because our dockets balloon out of control. We would have hundreds of people on the docket. Your case is 190 days old. It is time to decide what you want to do. So I will give you until Monday. What is today? Tuesday? Monday to decide what you want to do. If you want, you must at that time either accept or reject the plea bargain agreement from the district attorneys. If you want to apply for the intervention program, then everything must be submitted by Monday morning. If it is not, then you must accept or I will set your case for trial. Do you understand? You will get no more resets after Monday. Anything further?
So I need to pay what I owe?
I'm going to let you discuss that with your lawyer. It's probably a good idea to bring someone who speaks English to help facilitate the conversation. But at 100 and now over 200 days, when you come back, I'm not going to give you any resets. It is your guys' responsibility to find someone to translate. In the interim, if there are possible immigration issues, it is on you to go between now and Monday to talk to an immigration lawyer. I will not give you any more resets. The next setting is trial. Do you understand?
Yes.
See you Monday.
Oh, I'm a citizen.
Okay, out of an abundance of caution, I'm saying it to everyone.
There's one more judge. Is it fair?
I'm gonna quickly wet myself. Okay, who's next?
The last one is Mr. Lee.
Lee.
Earlier on. Him.
Yes.
He was rescheduled for tomorrow. That's the one about the contract.
Okay.
I do highly anticipate that it be submitted today, but I know he was rolled to tomorrow. But he did let me know about a trip he already has his.
I don't care. This should have been done a long time ago. I want to make sure that it gets filed. If you can file it now and they can file the supervision order, then we're good for tomorrow. But I'm not, no, it's 220 days old. At some point, we got to put it on.
I mean, everything in order is.
Hi, Brent. How are you? Happy Tuesday? I don't even know anymore. How are you? Great to see you. What's new?
Just got a crazy day. I've got.
How can we help you?
I've got a case of chief.
Okay,
Everything's good with you?
great. No complaints, just drama here and there, but I mean, that's what we do, right? I can't complain.
I just saw a lot right now. And my new thing, I got this thing now where when I see people, instead of saying hello or good day or, I ask, tell me something good.
Yeah, that's nice.
Because we deal with so much negative stuff that I think it's important that we don't lose track of the good things that we have going on in our lives.
A positive attitude can have such a great impact on everyone and and sometimes it's just really hard, so it's nice to really step back and just take a breather and,
Look at some child porn on Monday morning and I'm like, I gotta do I need to get some positive things.
And it seems now with the AI, I mean, it's just like, whoosh.
Yeah, I saw like they've been a big bust on some.
Yeah, I saw
some
that.
law enforcement officers like that. So,
No, multiple.
Oh, yeah.
So, yeah, those cases are always a doozy, man. I mean, back in the old days, I had a couple and they're just really, really tough. Just the DA's office, I don't know if they still have an office policy here or whatnot, but anyways, just think positive, my friend.
I like to focus on the good stuff.
Yep.
Yeah, so I'm gonna go around.
Have fun. Great to see you, though. Did I ever fucking? Okay, the two jail cases, the one jail. Still on, is there anyone else? Do I need to do anything else? That's right. Okay, I'll do that now. Yeah, I got it here. 263.
We might not get them.
Veronica, can I trouble you on Miss Jordan's case? Do you need the cause number? Just on the new one, I need a PSR, please. It's, cause number is 263-5558. I don't, or let me, you know what? Yeah, I mean, let me, if you don't mind, let me have one just in case, please.
So the other four cases got permissions from the different JLOs, from the random testing on those. She had random testing.
Can I go ahead? Can we go ahead and put them on? Yeah, and then I'll waive the signature if she's not here.
She's.
Oh, wonderful. Okay, great. Thanks. Hi.
Good morning.
Hi, Miss Brenda. Come on up. Good morning.
How are you?
I'm doing great. You?
Good.
Yeah.
I'm here,
Hi.
Mr. Ramirez.
Mary, jail or bond? Okay.
And he has an MAJ that's been filed. I talked to the state, if he is able to pay his fees, because I believe he was on probation for 18 months.
This counts, the case is 2,386 days old.
So
Where is he now?
He's here.
Does he have bond conditions?
I believe so.
Let's see, because I don't remember Mr. Ramirez.
He just got served with the MAJ, but I believe we have a resolution for what he's trying to see if he something's gonna be okay.
Tested positive for meth.
Oh, I don't have it. There's no.
Huh?
There's no receipt.
Okay. Yeah, he's looking at 45.
Okay, well, is there a way I can get a copy of the one you have? 'Cause this one.
Here, I'll print it out for you.
Okay.
It'll be next to Victoria.
Oh, wait. You said we're mirrors.
Yeah, that's right. It's for Miss Miranda. Christie. Hey, I printed it out for you. So if you want to take a week or two, but he needs bond conditions. So he needs a portable device. Hey, Victoria, do you speak Spanish?
English.
You don't speak Spanish?
Oh.
Does he speak English?
He speaks English.
Okay. Ramirez, come up. Drive. You do not have a Texas driver license, and I'm going to have you sign an affidavit. I really don't care what you have to do in this life. You've now, they have filed a motion to revoke the probation. We have one of two ways. You can either accept the agreement, or I will set your case for a hearing, and you will be looking at a year in jail. You are not to consume alcohol or illegal drugs, and you will get a portable device that you're going to take with you everywhere you go to prove to us that you're not consuming alcohol. You have 2 weeks to be back. At that point, if you're not ready to accept, then we will have a hearing on your motion to revoke. You understand?
Yes, sir.
Okay, all right. See you in 2 weeks. All right. Hey, so remind me, 45. Hi, Sebastian.
Approach on an agent before Astro update for everyone. I'm okay. That's the license Astro.
I think that's how we have it, right?
Victoria told me that there was something, that it was Castro, or one of them was.
Okay, I'm okay with it. Sure. Yeah, for sure. Hi. Just, my allergies are killing me.
Smith, we have the.
Okay.
Queue.
I'll sign it right now. Got it. Okay, I'm signing it. Hi, Mr. Weeks, come on up.
I just filed a motion a few months ago to motion the appointed as second chair.
Okay.
I know I asked you earlier, but I wanted to.
I'm okay with it. Yeah, for sure. Did he file a motion for continuance yet?
I'm not sure.
No motion for.
I can call Judge.
Please.
If it's on my motion, I can follow.
No. It's his case. He needs to do it. I guess we're gonna see him regardless tomorrow, right?
Yes.
Okay.
Getting with most witnesses.
Can you put Miss Green's case on for tomorrow, please? Okay, all right. I'll sign your motion. You got
Wait, is there order on?
it. You're back. That's okay. It's not a big deal. What's up?
Mr. Holland.
Holland.
She is a that put in another request for the living room.
It's 193 days. We're moving without it. I'm not gonna do it. Whatever's not in now is not coming in. And I'm surprised that it's waived at 193 days old. So we'll set it for all the day that you have next week as well. It's clear trial. By next week, hey, top of page 10. So they're having issues with the blood, ixnay on the blood A. So it's clear trial at the next setting. If they want PTI, it has to be submitted by the next setting. Same day as the next week for all the other cases.
How long's the sentence?
Just next week, whatever she picked for next week for all the other cases.
Okay.
Judge, for Mr. Ramirez, the MHA 2024.
This is the guy, yeah, we just spoke about it, the fourth time. Huh?
Okay.
Yeah.
What's up, to the PR bond?
Yeah, I said, yeah, I said yes.
Okay.
Well, you got to tell Veronica behind you.
Okay. Yeah, but she.
That's okay.
We were also.
But it's for tomorrow at 2 p.m. But yes,
Yes.
Yes.
We also wanted to amend the conditions. I talked to her about, it's been a crazy morning, apologies. Amending the bond conditions and the protective order, no threatening or harassing.
for,
CW.
I don't know. I mean, have you spoken to the complaining witness?
Yes, Judge, that'd be. She's been.
I'll tell her this request.
Okay, I need to amend and I need to speak to him though. Is he here?
Yes.
Because I have to admonish him. So, okay, file it and then we'll bring him out and I'll admonish him here momentarily. Yeah, because I have to admonish him. I have to tell him that no threatening or harassing, that we're amending it. Otherwise, he's just not gonna know.
Right, same, right. Okay. Yeah, fine. Oh, sorry.
There's nothing on the letter, but they can connect and create a custom. Is. You know, these things are like in the back.
Brett, who's your guy?
Robert Stephens.
Okay,
Let me know when you find it out.
I'm ready.
Okay, Serena's offered a custom PTI. He's been an inpatient treatment.
Sure.
He's living at a sober living facility out in Richardson, Texas.
Okay,
He's going to probably be there for about another, they think about another 6 to 8 months. Serena's gonna do a custom PTI that will basically continue doing that in aftercare. And so I just need to get her for some documents, some additional documentation. I'd like to come back maybe next week.
okay, I'm down. Yeah.
Everything signed and.
Okay,
On.
for sure.
Do that.
Okay, are you gonna follow a supervision order?
It's gonna be like a PCI, it's not gonna be, the DW on the PCI is gonna be a custom PCI.
Got it. Okay, but there will be a supervision order. Okay, sweet. Yeah, for sure. Of course. Hi.
Well, one of the other first thing I'll follow that. It's ours.
Oh. What was the last? Smith, right? Mr. Smith, come on up. So the idea is that if he goes into this, I guess, treatment, the case will be dismissed. You've got a really great deal going, Mr. Smith. All you have to do is go to the Ed Emmett Center, have an interview with them. And if you do that, this case will get dismissed. You understand? The other thing is I'm amending your bond conditions to allow no threatening or harassing contact. What you need to understand is what is threatening or harassing doesn't matter what you think. It's what she perceives. So if you go up to her and you start going like this, is that threatening or harassing? It is, and it can land you back in jail. Do you understand? I'm going to protect my community at all costs. You've been in jail for how long now?
Over a month.
How was it? Did you enjoy your stay?
No.
Great. It's not supposed to be fun. It's there to show you things. What happens when we act a certain way out there in the free world. When you do, there are consequences for action. Do you understand?
Yes, sir.
Okay, man. Good luck. Did you file it? So we had it? Great. We need them to sign and then we're good. Wow. Yeah. You ready?
I'm gonna supervise the first one and then follow.
Okay, come on. Rock and roll.
The bail review for fugitive case.
You want a bond?
He wants a bond.
Okay.
He would like a bond, for Mr. Solomon.
Do you want to bring him out? What a day. So last name was what?
Solomon.
Solomon.
No, you gotta scroll down. To the actual state.
Okay, you don't need to.
Hey, Victor, how are you, man? Happy Tuesday.
What's that?
Happy Tuesday.
Happy Tuesday. Happy to be here.
Yeah. Does he have a pool? Oh, it's Miss Ajay. Okay. We'll do your plea next, sir. Okay?
Thank you.
Yes, sir. You are Mr. Solomon. Good morning, sir. Your lawyer is asking for me to set you a bond. I don't know. You're wanted out of another state. We have to figure out whether we should give you a bond or not. Just because we can doesn't mean we should. So we're gonna get to know you in about 10 seconds to see whether we should or not. All right? State's gonna go through what you wanted for, criminal history, and we'll go from there, sir. Give it a second, and then I'll let you talk, but let's figure out what's going on. I have no idea of anything. Okay?
The defendant has a warrant out of Wood County, Ohio for an FTA for drug possession and trafficking. It was issued May 2nd, 2026. There is another outstanding warrant out of Bowling Green, Ohio as well. It does not specify. There's been 2 previous warrants for him in his past criminal history. He has had
2 fugitive warrants?
2 warrants listed for him by other counties, jurisdictions. He has a long list of violent crime history, armed robbery, felony possession, assault and battery, firearm possession by a felon,
Recent or old?
dating back from 2006 all the way up to
I mean, how recent are the violent offenses? Because that really concerns me. If it's recent, then I've got a problem.
The assaulted charges or the.
he has a felony firearms charge from 2009 in one jurisdiction. There is,
Actually, Your Honor, this those look like this. The previous parts were accurate, but they're typed as FBI numbers, but the ones for the audio robbery are not.
Which jurisdiction wants him? One or both?
one, Wood County, Ohio.
So the other jurisdiction
The
doesn't.
other Ohio jurisdiction, I guess.
They're not.
It could be that they didn't confirm, it could be that they didn't want to pay the money, it could be that they haven't gotten approval from their DA, it could be 1,000 different reasons, but it's all at the sheriff's office stage, not at the DA stage.
I think I can assume what your position is on a bond. Okay, Ms. Kuhn, ball's in your court.
I would ask for a surety bond, which is affordable. Mr. Solomon, Mr. Solomon can afford a surety bond of $1,000. And he'd be able to get to Ohio, he has transportation there. He has family who lives here. He also has connections to Ohio, so he'd have a place to stay when he goes there. He understands that he'd have to turn himself into Ohio within 14 days of being released, and that if he didn't, then there's gonna be a warrant here and a warrant there, and this problem won't go away. I've made this very clear to him.
Just 2 prior fugitive cases?
2 prior warrants out at some point for him, not fugitive.
He's just had.
Your criminal history and the fact that you're wanted out of 2 jurisdictions is concerning to me, Mr. Solomon. If you want me to set you a bond, I can, but it's going to be a high bond. This isn't a revolving door where you just get to walk in and walk out, and especially with the dangerous history. So if I set you a bond, it's probably going to be somewhere in the neighborhood of around $7,000 to $10,000. Has he waived already or no? Do you
He
know?
has not signed a waiver. He would sign a waiver if he could not afford the bond. It's my understanding that he'd be able to afford a $10,000 bond. $7,000 would obviously be preferable. He was not aware that he had these outstanding warrants, and in fact, it does sound like a heavy charge.
I get it. Nevertheless, you still have two different warrants out of two jurisdictions, a significant amount of criminal history. So I have to ensure, number one, that this, if we set you a bond, you understand how serious this is, because if you do bond out, we expect you to immediately go back to Ohio. The other problem is I don't want you to leave a wake of destruction on your way back. And with a bond amount, hopefully that's enough of an incentive for you to understand that when we say something, we mean business. You're old enough to understand that actions have I want you to listen for a second. I know you're trying to think of things to say, but you're not going to hear what I'm saying. I don't do this over and over. If I set you a bond, you get one opportunity. If you fail to do what you say that you're going to do, I will revoke the bond, set it at 0, and I will not give you another one. I will issue a nationwide warrant for arrest. You can't run forever. I will get you, and this time I will hold you until Ohio comes and gets you. Do you understand? Okay. I'll set the bond at 10,000 for what he said he could afford, and we'll go from there. If you want to make the bond, okay, we give you 14 days from the date of your release to turn yourself into Ohio.
Would you be willing to go to $7,000?
No. He's got 2 open warrants in 2 different jurisdictions, a lot of criminal history, and it's violent. So if your other option is, if you want to waive extradition, we give the demanding jurisdiction, Ohio, 14 days to come get you. If they don't come get you within that time, Harris County releases you.
Your Honor, I need to reach out to his family on his behalf
Okay.
to ascertain that they deal.
Sure.
And then we'll make that decision.
We'll give you time, as much time as you need. Understand, though, that while you have refused, the clock for them to come get you, you've not waived. So you either waive or refuse. If you refuse extradition, the clock is not ticking for them to come get you. So the 14 days is stalled until you either waive, or I guess, yeah, just until you waive. At that point, that 14-day clock will start ticking for them to come get you. Do you understand?
I'm gonna talk to you and I'll call your family for you from that.
Okay. If he doesn't want the bond set, then just let us know. We can have him do the waiver and then go from there.
Very briefly, Judge, on the other one, I just want to, I was mistaken. I thought it was under chapter 51. It's not, it's under chapter 17. 1703 is what prohibits personal bond because it's not one of the enumerated ways.
Are you talking about with,
Well, just in this in general, in all bonds, it's under 1703. I thought it was under chapter 51. I was mistaken. It was 1703. So because it's an administrative case, it's not one of the enumerated offenses. A personal bond can't be granted to the cases.
show me the section so I can see it.
Well, 17, so I printed all the other ones except 1703 because it didn't print, but on the list of 1703, I'll obviously.
Okay.
Section mark. I checked with Megan just to make sure I wasn't going crazy, but.
And then
I was just looking at
you
it.
take a look as well.
That might be at the magistrate level that you're not able to.
It's okay. You've got time. Take a look. We'll take it up tomorrow morning. That way you have enough time to look at it. I'm not going to make a decision until at least you take a look to see, so you do your diligence and.
Thank you, Judge.
Yeah. Okay. Okay. All right. Good luck, Mr. Solomon.
Jordan?
Brent, what's up?
Are you okay if we can do everything remotely, and have them sign?
Sure,
And
of course.
everything, so.
I trust you.
Have to appear
Yes,
personally?
I trust you.
Thank you, Your Honor.
All right. Good morning. Oh, we need a oh, there you are, Luis. Good morning, Mr. Presa. Sir, you're charged with driving while intoxicated, second offense. You are facing up to a year in jail and or a $4,000 fine. The agreement that you have worked out is 30 days in jail with credit for the 16 days that you have done. You need to understand something very important, that this is now will reflect as another DWI conviction. If you ever pick up another DWI, you will be facing a felony charge of at least a minimum of 2 years in prison, a maximum of 10 years in prison. Do you understand? If I were you, even if you have a sip of alcohol, I wouldn't get into a car. It is a huge risk. Do you understand?
Yes.
You are giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty to this offense, it will go on your record. You can never take it off. You understand?
Yes.
Is this what you want to do?
Yes.
How do you plead to the offense of driving while intoxicated, a second offense? I'm going to find you guilty. I will follow the agreement. I'm going to suspend your license or ability to get one for 1 year. Do not drive until you get a license. And good luck to you, sir. Thank you. Good to see you. Yeah.
Miss Jensen?
Yes.
I'll give it.
Hey. Yes, of course. Hey, Vic, you want to go through the list?
Yes.
Victoria, you want to go through the list?
Can I give you a case number? It's off that way.
Yeah.
26.
Okay.
0484.
Okay.
Came in early because he couldn't make it on Monday.
Canales, come up. Did you get the cause number, Shan? You got it?
It's just not the internet.
Yeah. All right, you are Mr. Canales.
Yes, sir.
Sir, you're charged with unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. Okay.
Judge, our system is like down. It's loading. Judge, he was, I believe THA. Oh, you got a class number?
Yeah, 263-0484. Oh, so we've already done probable cause?
Yes, he was THA. Mine is loading.
I don't have bond conditions signed, or let me see, maybe this is it.
Yeah, there it is.
This is an old case. All right, Mr. Canales, do you have a lawyer?
Not yet, sir. I was gonna ask about getting a court attorney.
Why?
Can't really afford to put money down on one right now.
Why?
I'm not currently working very much. I'm doing DoorDash. I just got the vehicle back.
You're not, you signed an affidavit not to drive. You don't have a Texas driver license, sir.
I do. It's eligible now. I paid the suspension.
You're supposed to come talk to us.
I did. I called the court and she said as long as it's eligible, then I can drive.
I have a court order and I have to undo the court order. No one can tell you anything. We document everything. You cannot just come here and say, oh, I talked to someone on the phone. Who did you talk to?
Whoever answers the phone whenever I call.
Santa Claus? Right. This is a court. We work on proof, not on spoken word, not on the gospel. We work on evidence-based decisions, and we do stuff in paper. Publish or perish. You understand?
It's showing cancer. Unless, but, I'm showing like a Louisiana, we're trying to run it in. If there, if he does have anything available that we look at, we can run that number. But right now, just running what we have in our system is showing cancer driver's license.
I can show you on the website where it says that I'm eligible. I have an SR22, I bought insurance.
So I cannot give you legal advice and I cannot talk to you about the case. I just look at what they tell me as far as the DPS system is concerned, and we make decisions on that. So
And I did find another number that we're trying to run it right now.
this is why you need a lawyer to represent you, to navigate through these. You don't do stuff on your own. When you do stuff on your own in the criminal justice system, it tends to not work very well and in your favor. Do you understand? Right. It's now nearly 12 o'clock. So let me ask you this. Did you speak to any lawyers?
No, I haven't spoken.
So how on earth do you know that you can't afford one then? If you've not
I
even
got a
spoken
bunch of
to not,
advertisements since the court date, whenever I came up here.
okay,
And it's
did you
all like
call,
thousands of dollars.
but did you call any of them?
No,
That's a
I
no.
called the court to ask if I could apply for a court appointed.
Everyone wants a court-appointed lawyer, and I have very limited resources. I don't have unlimited resources. So we really have to see who qualifies for a court-appointed lawyer, and it's based on the federal poverty guideline, meaning that you make around 17,000 to 18,000 a year to qualify. We don't just give out court-appointed lawyers like it's candy on Halloween. You have to qualify. So if you're making thousands of dollars a month, from whatever means it may be, you're just not going to qualify for one.
So we have an update. We were able to find a different driver's license number for him that does show that it is valid. It expires in 2033.
Okay.
We have a no liability insurance hold that was listed on 7/24/2020.
So he's valid now. Is it a Texas or it is a Louisiana? Okay.
Previously was Louisiana, but now he has a Texas driver's license.
Okay, let me make a notation now. So I will take off the no driving affidavit so that you can drive legally. Just make sure that you have liability insurance because that's required by law. All we ask you to do is follow the law. You are not allowed to be in possession of any weapons. You understand? I don't care.
The evidence thing I had, I'm trying to get.
This case is open. I have put bond conditions that you're not allowed to have any weapons. Please don't have, okay?
They also told me to wait till the court date to ask them for a court attorney. Yeah.
How much money do you make a month, Mr. Canales?
I haven't worked in a couple of months because I wasn't.
You were, but you told me that you were door dashing and that you were.
Right, that day that I had court, I had bought a car the day before with the last time I feed.
So you have enough money to buy a car.
Yeah, so that I could.
What kind of
I
car
didn't
do
know
you
my
have?
license was suspended until.
I'm not going to talk to you about the case.
Yeah,
I
okay,
only
sorry.
want to know whether you can afford a lawyer. So you just
Right at the
recently,
moment I can't, I'm before court.
you just recently bought a car.
Right.
What did you buy?
It's a 2006 Honda CRV.
Okay, so let's do this. It's now noon. All our lawyers are gone by now. I can send you home with an application. We can have you come back. I need you to fill it out. I need to know everything about you, how much money you make per month, how much money you have in the bank, what kind of cars, property, stocks, bonds, mutual funds, IRAs. And then I'll take a look to see whether you qualify. But it's evidence and it's income based as to whether you qualify. Every single person that comes in here wants a court appointed lawyer, and we just don't have resources to give it to every single person. I just don't. Right. Just Everybody thinks that, okay, I just caught a case, I'm just gonna get a court appointed lawyer. It doesn't work like that. You have to qualify. Deputy Williams will give you an application. We'll set you off for a couple weeks. When you come back, have it filled it out, and then we'll check it. Okay? Please.
You just want to keep that day and bring that thing back.
Well, that's what I was gonna ask about changing that day.
Oh, okay.
So one time, I think I was there.
I was on board.
Even just a couple of days. And I would just went down for an entire office.
No.
Wasn't it? At least we're, the orientation was down for an hour, so I assume that you were down for. Wasn't that bad? Went on the 5 hours, we're down yesterday.
When you get kind of back, I get chilled out. Yeah, I know. Victoria.
I keep running out.
I guess we'll talk about it. Hey, Mr. Johnson, how are you? You can, no one does anything, no one cares. I know, I feel your pain.
Terry Leonard, I was just playing a few minutes ago. He's in
Back there,
custody, right?
okay,
Yeah.
Leonard,
Terry
Leonard.
Leonard is his name.
okay.
I don't know if we got a PC on him yet, so.
You want to do PC? It's already done through the magistrate, but if you want to redo it with me, I'm happy to do it.
Definitely, I'll love to.
Okay, Leonard.
Or we can we'll approach the name. No, I just got appointed.
So he's on deferred for PCS, has R2, and then, oh, man. Picked up the case upstairs too. Okay, you ready?
I haven't got, oh, I just got the appointed email, wow, so I can see the call number two.
Listen, Marshall safety. Yeah, she has the. But this one, I don't.
Yes, so that we guys email them.
Yeah, it's here.
That's okay, I don't know. Email.
Hey, you talking about bottom of 2? Hey, you talk about bottom of 2?
Yes, Judge.
So I guess a couple weeks to make a decision, but dude gets an ankle monitor today.
Okay, you're gonna.
Yeah, the case is 2,000 days old.
Okay, yeah.
On Amaraz.
Fill in for Marco on it.
Yeah, that's okay. Mr. Amaraz, your next setting is plea or trial. It would be a good idea for you to go through the evidence with your lawyer, but that is the last reset that you will get. Do you understand?
Yes, sir.
Okay,
I will not, you told me, Judge. Okay.
You ready? Yes, Your Honor.
Okay.
On August 21, 2026, at approximately 12:25, officer observed and measured a white Nissan Roof bearing a Texas license plate, speeding 70 miles per hour in a 50 mile per hour zone eastbound on San Luis Parkway, Harris County. Officer initiated a traffic stop and discovered the defendant had no driver's license. Officer instructed the defendant to exit the vehicle. Officer then performed an inventory search of the vehicle and immediately observed the butt of an unholstered handgun positioned between the driver's seat and center console.
Yes, for the unlawful carry.
Why would he just start searching? Is he black? He's driving while black or what? It's a suspended license case, right? I mean, was it in plain view? I mean, I'm down with the suspended license case. I think that's a good case, but the gun case,
There you go.
I don't think so.
The judge indicated that he's been saying that he was going to do an inventory search of the vehicle was going to be towed. So it says, Affiant informed the defendant that the vehicle would be towed and place him in the rear of the Affiant's patrol vehicle, and that's when he did inventory search of the vehicle, and that's when he found the handgun.
Did you file an inventory?
Because he was going to arrest him because of the history of multiple DWLIs.
Oh, I don't see multiple DWLIs, but nevertheless, because when Shantia read it to me, it's just, I pulled him over. I'm just gonna start searching.
No, so, from what the DIM summaries indicate was that the officer conducted the traffic stop for speeding. After reviewing his criminal history, revealed that the defendant had multiple prior convictions for no driver's license and failure to maintain financial responsibility. The defendant's most recent conviction, was on May 19, 2016 out of Harris County, Texas. He had a total of 4 prior convictions for no driver's license and 4 prior convictions for no vehicle insurance. Officers requested for proof of insurance. Defendant was unable to provide it. They asked him if he had any weapons or anything illegal inside the vehicle, to which he denied possessing either. Officers then told him to exit the vehicle, observed him remove the upper portion of the seatbelt from his body, revealing that the defendant had not been properly wearing the seatbelt and had instead been sitting on top of the lower portion of it. While completing the traffic stop, officers were preparing citations. They gave him ample opportunity to provide the financial responsibility. He did not have it. So they told him they were going to tow the vehicle and place them in the rear of the patrol vehicle.
Okay.
For arrest.
I mean, that's better than how you had initially read it. I mean, okay. All right. I mean, there's PC.
Understood.
Yeah.
PC, but you requested inventory, the copy of that inventory that was filed?
Yeah, if we do, usually have a tow slip that they might, put in there, I will request that.
Because it was actually inventory, so they'll have an inventory.
So where did the bribery come from? Did he, is this out of the same?
Reading the dates.
Yeah.
So after the inventory search, the defendant was on a phone call with an unknown female. The defendant stated, he's searching my car, mama. The female replied, is the gun in there? The defendant immediately turned the speakerphone and stated, I can't hear you. And then said, yeah. The conversation provided defendant with knowingly possessing a firearm. Let me see about anything in regards to.
I mean, it doesn't really matter. It doesn't.
Oh, here it is, Judge. The defendant subsequently offered a fine of $2,000 in exchange for releasing him from custody. The defendant specifically stated, bro, I'll give you $2,000, bro, take me home. A fine stated he couldn't hear what the defendant said, and then the defendant repeated again, I said, I'll give you $2,000 if you take me home.
Okay. The bonds are set pretty low. I'll leave him as is. He's got other things to worry about regardless, so whatever you want, I'm down. Yeah.
You see that little down, or are they right?
His bond right now is $500.
Okay. Thank you, I appreciate it.
Okay, thank you, Mr. Johnson. Are you guys waiting on us?
Oh, were you calling us? Judge?
Yeah. I'm ready for you if you need me.
We just wanted to confirm that Mr. Solomon would like to have his bond set at $2,000.
Okay,
That's it.
I'll set it at 10. All right.
Mr. Allen's device, is it GPS or
GPS. It's,
He currently has a GPS for a felony.
oh, he's got a felony case too?
You did your invitation. I already know that because of the people from the town.
Yeah, I know, just a GPS monitor. Yeah.
Oh, you know, I'll talk to you. And then depending on the extent. You know, so.
Approach on case regarding Daniel defendant,
Regarding who?
a Daniel Reed. Last name.
No. What was the lawyer's name? He approached on several people, but I don't remember what the defendant's name was. What's it regarding? The name change? No, that's the other dude. What is it?
Under 6 feet. But at that point, you wanted to.
Did you talk to Sebastian regarding Reed?
He did not talk to me.
He wants, what is it, medical record? No. It's like
Order to obtain medical certificates.
order to obtain medical certificates. Read.
It's usually Lawrence Stewart who handles the mental health issues. I'm not sure. All of them.
Yeah, I guess if you want to check with Sister Lauren,
I can double check with Lauren.
see if she's okay with it, and then if she is, then I am. Hi, Lisa, I see you. What's up?
Judge, I had Mr. Lucille on the docket today.
What's the last name?
Lucille, Raymond Lucille. Yes.
Okay.
A month ago, we received an ARA and he updated, I sent the copy of he's enrolled in both BIP and parenting classes. They're starting like this week. And I sent copies of that to the DA yesterday and to Victoria this morning.
Lucille is the last name. Does he have 4 classes done?
No, because when he had to go through Harris County to get all of it set up and they enrolled him. It starts this week, I think, is his class, when his classes start.
Oh my
The
God.
email he
This
sent me
case is
was,
gonna be forever.
well, we only received this a few weeks, like 3 weeks ago, the ARA, or a month ago. And I think he went right away and
I
tried
have
to
it that July 21st is when.
right, so that's like a month ago. I think I got a letter from him that said that that probation is the one who set it up for him. So I don't know if he had to go through probation to get it. Yeah, that was the email that he sent me with something. It had a document attached that said he's registered for both classes, but they start like later this week.
Okay, I mean, this is really old, so I'm not doing long recess to see whether he complies with it. If he misses one class, tell him he's out because it's old.
I'll let him know.
We'll give you 30 days. He's
Okay.
got to have at least 4 classes done by the next setting.
Okay, I will let him know. Thank you.
Hold on, I have to get your date.
Yeah.
30 days, Judge?
Yeah, on bottom of 13.
All right, how's September 24 or the 30th?
The 30th works.
Okay.
Thank you.
Required, always required because it's old, and in the event that he doesn't comply, then he's got to be here. Yeah. All right, Lisa, we'll see you.
Okay. Okay, thank
Have fun.
you. Bye-bye.
Bye.
He's signing in.
Yeah, mine just started looking at the reset it.
Hi. Happy Tuesday. What's up?
I'm one on docket today.
Sure.
Miss Amanda Phillips.
Phillips.
She's in custody.
Okay. Anything in particular you'd like?
I guess unfortunately to get please get PR on.
Did you just get appointed on it?
Yes.
Okay. What say you state? What's your position? Phillips. Is she on bond for anything else?
No, she doesn't, she only had one prior arrest from 2023, it was a criminal trespass, she has no violent history, she's.
So let's read this because usually most on a first offense get out
Right.
unless there's some kind of, I don't know. So I'm going to read to you. I swear. This is the reason for the bail decision. GOB eligible as charged, mismarked by the district attorney's office. So PTRB granted with bond conditions, entered to reasonably ensure community safety. She was given a PR bond.
Yeah, she did tell me she refused it initially.
She refused it.
Yes, and then she changed it. Because she expressed to me that she wasn't sure if she would be able to make it to court the following day, in such a short amount of time.
Well, they usually give them a 7-day setting.
That's what she did.
Do you mind bringing her out? Phillips. Have you spoken to her? Have you spoken to her yet?
There may be potential
No potential what?
mental health concern, just.
I get it. My only concern is, does she have a place to go to, or is she on?
She said it would be like a family member, she gave me her brother's number, so that's what she.
Okay. Who's the complaining witness? Ms. Shaw.
It's her father.
I'm surprised it's not upstairs. I'm surprised it's not upstairs, huh? Maybe it wasn't bad. I don't know.
Somebody else, I believe, was involved, and one of her cousins who is upstairs.
Oh, so there's a co-defendant.
I don't know if they're current, but somebody else was.
All right. Well, I guess we'll figure out. Good morning, Ms. Phillips. I'm bringing you out because I'm trying to figure out where we should go with you and the case. You stand charged with assault of an elderly or disabled individual by contact. That's why.
And he said we had told him he wouldn't be okay.
We'll get there. You're facing up to a year in jail and or $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. Okay?
On 8/20/26 in Harris County, Texas, officers were dispatched to a disturbance call and made contact with defendant and complainant. Complainant is the defendant's biological father. Defendant was accusing complainant of causing her mother's death, who's CW's wife. Defendant began to make offensive contact, such as kicking him multiple times in the shin, slapping him in the face, striking him in the body, and attempting to kick him in the groin. Complainant stated he did not feel pain, but stated that his daughter should not be hitting him. Complainant wished to pursue charges and a protective order. Complainant is 67 years old.
Is this a class C assault that's elevated to an A because of the elderly? Or is it a true class A? Because if there's no pain, it says on August 20th, the then and there unlawfully, intentionally, knowingly cause physical contact with the complaining witness by striking the complainant with her hand, and the defendant knew or should have reasonably have believed that the complainant would regard the contact as offensive and provocative. How on earth can you get into someone else's mind? It is further presented in Harris County that the defendant heretofore on about August 20th, the then and there unlawfully, intentionally, knowingly caused physical contact by kicking the complainant with her foot, and the defendant knew or reasonably should have believed that the complainant would regard the contact as offensive and provocative.
I charged it like this because he said that he didn't feel pain. So they're dealing with him.
This is a first for me. Phillips. It's an assault where you don't have to have any kind of injury or pain. That's a class C.
Yes, but I think it's enhanced because of the enhancement paragraph is because of the elderly individual. So that enhances the judge.
I'm going to find it for now. If you want to do any kind of research to see whether you think it passes muster or not, just let me know. And I'm willing to, hear it in a week or 2 weeks, whatever you want. Ms. Phillips, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you are not allowed to have contact with this complaining witness. Do you understand? If you violate this condition, I will revoke your bond and put you in jail. I'm entering now a protective order that identifies Mr. Phillips as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon. You understand?
I understand.
Okay.
Another,
Do you want a PR bond, ma'am?
I would like it.
Okay, just look at me. I want you to understand something. This is not a revolving door. Everybody deserves a chance, and I'm going to give it to you, and I'm going to give you a PR bond today. But this isn't something where you're going to get PR bond after PR bond. If you pick up multiple cases, it may not go well between us. Do you understand?
Yes.
Okay, all I'm asking you to do is be patient with people. It's not hard. If you're upset at someone, walk away, go outside, but just don't have contact with this person, all right? The only other thing I'm gonna ask you to do is stay in contact with her so that you guys can always remain on the same page. As long as you remain in contact with her, I'm gonna waive your appearance for the next couple settings, meaning that you don't have to come back. But if she tells me she cannot get a hold of you because you're not responding to her, I will issue a warrant. Do you understand?
Yeah.
What is your question?
I don't have a formal contact. But
As long as you have a place that you're staying, like your brother's house, a sister, an email, it is your responsibility to stay in touch with her, not anyone else's. Do you understand? Okay. All right. So we'll have her sign them up. Can you create the bond conditions? We'll have her sign it and then I'll grant you the PR. Yes, ma'am.
No contact.
No contact, no weapons. That's it. And then she'll sign the PR bond or the bond.
I have the code to make sure that it's 224183C. That is assault class A with an L.
Usually the enhancement only brings it up one level though, right?
So under this code, Judge,
Well, yeah, there's only a class C or class A. There's no class B assault. But it's only one level of enhancement when you enhance something. It's weird, right? It must be, I don't know. It's first for me. I've never seen that. Hey, you want to stay here all day or what?
Yes.
I thought you did. Come on.
Bottom of 5. What's going on with that? Council is here, defendant is here.
Wait, what was your note?
I'm sorry.
Bruce.
Yellow hash. Cruz is alive. The council was here and she said something about disposing of the case today.
It's a guy
They're partners.
Oh,
Judge.
yeah.
She cleared that
She's
up.
completed,
Oh, did you dismiss it?
yeah. I believe I did, that you don't have a dismissal yet?
Let me look.
Okay,
I'll file it.
Okay, they're going to dismiss it.
The next one is top of 8. Set for Raymond Township here.
2501.
Bottom of 9. It's a PCI, DWI PCI. Oh, dismissal file. Oh, right. Page, page 11. Last name Jordan. So Karina said she covered it was complete, but then Leonard said it wasn't. Jordan? Yeah, I forwarded that email to you. I want to confirm her reply.
It's only 63 days,
Yeah,
right?
it's very young, but if it's complete, it's complete. It will move along faster.
What's the deal, Pickle?
I'm looking right now.
Right. I like to move
He
it,
said
move
he's
it.
missing, he's requesting those lists, Judge, so I'll pull up the information to see what we don't have. Because he said he's missing
A co-slip
and 12 paperwork.
on the interference?
And he also mentioned something about wanting discovery for the previous case.
But didn't you offer a PTI?
Pulling it up.
And didn't you say he accepted a PTI?
No,
Oh,
saying that he was missing discovery.
okay.
There was a clarification.
Yeah, so that's what he was requesting is not normally done. So it's like additional discovery he's requesting, so we would have to, our additional discovery is complete. He's requesting additional discovery.
Okay, not a problem. It's only 63 days. I don't care. I don't care. No.
Okay,
I watched Harry Potter last night. I don't care.
Judge, you want to stay here all day?
Touche.
Page 16, 2 bonds posted.
5002.
Yeah.
Yep.
That's on Parker?
T,
T,
16.
Bottom or top of 24 is a required hearing. Council said defendant is MIA.
Who, which one?
Top of 24.
5001.
And Stacy has bottom of 27.
What's the deal?
Your Honor. Yes, the state offered us a PTI yesterday, and actually today they offered us a shorter anger management course.
Great.
I did talk to the client, however, if the court could explain his options.
Tingle. Go around. We don't want you next to the DAs. Pretty good. How are you, Mr. Tingle? There's an expression that goes, never look a gift horse in the mouth. Have you ever heard of that? So what that means is that, you know, when someone may be offering something to you, you know, be careful what you wish for in this life. You know, it may tend to backfire because you never know what's going to happen in a jury trial. I've been in jury trials where I thought it was slam dunk guilty, where they came back not guilty. And I've been in other ones where I thought it was the other way around. You were set for trial today. They've offered you a short anger management class, like a 2-hour. If you do a 4-hour anger management class, literally